Your Lordship's kind leave to mention, my Lord, it's an application in connected section and proceeding. The time to submit, furnish my bank guarantee in terms of the order has expired, my Lord. I'm seeking extension under this application, my Lord. My Lord, I'm mentioning up a notice. Great.
Your Lordship, in the non-commercial list, item 13, 14 and 131, they're all connected matters. Your Lordship, the learned senior from Bihar, he had mentioned the matter earlier. Today, one matter is fixed. If the matter could be taken up tomorrow, Your Lordship, subject to Your Lordship's convenience. 13, 14 and 131. They're all connected matters. Execution 34 and 36.
Ketan Construction.
Bed, in the non-commercial list, Your Lordship. Bihar Medical Services Infrastructure Corporation versus Bed Power Services Private Limited. My learned senior has travelled from Bihar to do a matter today. He's here. He'll be coming at 2 p.m. I was praying if these matters could be taken up tomorrow at 2 p.m. I have already taken consent from the other side.
Today 2 p.m.
Today 2 p.m. another matter is fixed, office. So I was praying if it could be taken up tomorrow.
Have you informed the other side?
Your Lordship, I have served the... 13, 14, 131. 13, 14, 131. Sincerely obliged.
May I have your Lordship indulgence to mention an execution commercial matter? My only request, if it could be put as to be mentioned tomorrow, I'll indicate. For the last year, we had substantial arguments were made before Justice Sarkar when she was having the determination, and we were on reply. If, with the consent of the learned other side, we would seek a prayer for release so that we can go back, because otherwise, again, we have to do the entire re-hearing.
Have you spoken to the other side?
I have intimated them. It can come as to be mentioned tomorrow. Then again, we have emailed him mentioning on notice. It's to be mentioned tomorrow. Then we can have.
Both the parties are agreeing. Then I can release it. Can go before.
I think, in spite notice, they are not.
Mention tomorrow. Mention it tomorrow with the other side.
Okay. Okay.
Your Lordship, item 12 and 18 of the non-commercial list, the urgency is that the execution application has been fixed on 17th for filing of affidavit of asset. The erstwhile advocate in a section 11 application had filed a section 34 application. So my application right now is for converting the section GA application into a section 34, allowing Your Lordship. And we had made our arguments. If any day, Your Lordship, subject to Your Lordship's convenience, any day Your Lordship could take up.
Can't be done.
Item 12, Your Lordship.
No, not now.
My Lord, may I be permitted to mention a contempt application? This was mentioned to my Lord right before the vacation. My Lord had allowed it as well. My Lord had passed an order in 2025 of June. The contemners now, they were supposed to abide by my Lord's order within 4 weeks. Nothing has been done, my Lord.
This is what pension
No, my Lord. My Lord, it was a direction upon the Darjeeling Municipal Corporation to conduct a hearing and pass an order for the demolition of a unauthorized building.
My Lord, may I be permitted to mention one AP Com number 832 of 2025 for inclusion in the daily list?
Inclusion, not right.
No, it's a application under section 29A. I want the extension of the mandate of the arbitral tribunal, my Lord.
Is this the extension?
Extension.
May I be permitted to mention a matter, my Lord? For inclusion in the list, it's an execution commercial matter, my Lord.
Not right now. After 2 weeks.
My Lord, may I also request the inclusion of a execution matter, my Lord?
Lord, I'm praying for an inclusion of a matter. It's an execution application.
Not now. Yes, judgment.
I appeal the writ petition.
In the light of the above discussion, this court is of the considered view that the objection raised by the respondent municipality are unsustainable in law and unsupported by any statutory provision. The development proposed by the Shibats is not an act of alienation, but one of preservation and beneficial utilization of the deity's property. The insistence on obtaining a court order prior to processing the building plan is therefore arbitrary and devoid of legal foundation. Accordingly, the respondent municipality is directed to forthwith process and consider the petitioner's building plan application in respect of premises number 59 Barrackport Trunk Road, Pikepara, strictly in accordance with the applicable building laws and regulation, and to take a final decision thereon within a period of 8 weeks from the date of communication of this order. With the aforesaid observation, the writ petition stands allowed.
Great.
But appeal is allowed, my lord.
No.
The application, my lord.
No. Yeah, as it is, I'm trying to sit 10 minutes late only so that the lawyers don't have any difficulty. And then you come after 20 minutes to mention a matter. You should mention at 12 o'clock. Yes, call out the list.
Lordship, I'm here for the petitioner. The dispute between the parties has been resolved. I'm withdrawing the matter upon receipt of the written instruction from the client.
Take down. Learned counsel for the petitioner submits that the matter has been amicably settled between the parties. Full stop. He has handed over a copy of the instruction instruction from his client, wherein he has been asked to withdraw the present petition. The present petition is dismissed as withdrawn. Copy of the instruction is taken on record. Yes.
But this has come up, my lord, for fixing a date of hearing, my lord. Any day, my lord, next week or, my lord.
One is my learned friend's execution application and one is my lord the award debtors application under section 47.
Lord, any day convenient, my lord. Next.
Let me see. How much time will it take?
It will take a little time. There's an award against the government.
I don't think, my lord, before
more than 2,000 crores.
What, my lord, it should not, my lord, take.
Well, the government, my lord, is in the red for 2,000 crores. So, my lord,
Section 36, my lord, we filed. My lord, deposit order, my lord, not deposited, went up to the Supreme Court. That, my lord, got dismissed. The special petition, review dismissed.
Supreme Court has said that, my lord, parties are not amply protected.
My lord, kindly, my lord, put it any day,
Yes,
my lord, convenient.
let us not argue it now.
Yes, yes.
Well, apart from 17th, 18th, 19th, these 3 days, my lord, I'll request you. 18th, Mr. Banerjee is opposing me in Delhi. So.
When do you want both of you? I mean,
21st.
You both of you are busy counsel, so please see your calendar.
After the 20th, any day. After the 20th.
21st, my lord, if it's possible.
It's a Friday.
No, then
it's a Friday.
20th.
My lord, may I request an early December, my lord, any date that's convenient to you?
Early December. 25th, 26th corona.
Oh, Siddharth, unless Siddharth is there, I can't do this.
27th.
What about 25th November?
My lord, my learned friend comes from Delhi. My lord, he will be in some difficulty, he can't travel. My lord.
So what about
26th, 27th,
20th November?
I have something already fixed for 3 days continuously. Your lordship may fix it sometime in early December.
Early December?
We were trying for November. If
all right. Shall we keep it on the 2nd of December? Will that be convenient?
Yes, yes, my lord.
Very well.
Yes.
First or second.
At the request of the parties, let this matter be listed on 2nd of December.
I'm very grateful.
My lord, any time is it possible, my lord, subject to my lord's
Mr.
approval and
Banerjee, don't
convenience?
fix a time. Then it
Very
gets
well.
very difficult for me. You know,
No, no, my lord,
Well,
we will
as
we'll try to take it up. And
very well.
grateful.
But naturally, my lord, being an unsecured award in that sense, my lord, we are more, my lord, in the rush, my lord, to try and have it
My learned
executed.
friend cannot help argue the matter.
We are trying to have it executed. True. My lord, if my learned friend, my lord, was trying to, my lord, enforce an award, my lord, which is 2,500 crores, my lord, he will also have, my lord, done the same thing. Grateful.
Appealing for the respondent award holder, Lordship.
Lord, I am appealing for the petitioner, my lord.
I do not know why this has come. This is
Don't know, my lord. আমি তো মেনশন করি না আপনি করেছেন আমি তো আবার আপনি করেছেন
you're not following you're the petitioner.
I am the petitioner, my lord.
You're not following the direction of the court.
My lord, I have already submitted the amount, my lord, the award amount.
By how? Check.
My lord, the demand draft, my lord.
Not demand draft, it's a check. Madam, it's a check, not a demand draft.
Well, as per the
Action is, see the order. What is the order? Why do you think the bank has refused it? You have to comply with the direction of the court.
My lord, may I submit, my lord? My lord, I have personally visited the office of the Registrar General, my lord.
Yes.
My lord, he instructed me to file in this way, my lord. Maybe, my lord, it's my mistake, my lord. And on his instructions, my lord, I filed this.
Take down. The petitioner has submitted a check bearing number 10932, right?
10932, my lord.
Dated 13/10/2025 in compliance of the direction of this court, dated 20th/8/2025, full stop. On presentation, it was returned by the bank with an objection, inverted commas, kindly contact drawers, inverted comma, close, full stop. Learned counsel for the petitioner is directed to submit a demand draft of equal amount in lieu of the dishonored check within a period of 2 weeks. 1 week?
yes, Lordship.
With a period of 1 week, full stop. The dishonored check shall be returned to the learned counsel for the petitioner on submitting the demand draft as aforesaid.
My lord, the check number is 1059532, my lord.
Where's the check?
Achieving the parent order, I'm sorry.
Yeah. One zero nine five three two.
My lord, 109,532, my lord.
Achieving the parent order.
Yeah.
In the parent order, there was a default clause that if they do not submit, I will be free to execute. Lordship will kindly clarify in this order as well, because otherwise, if they do not submit, I have to again, in the Lordship sees
My lord,
an
I have
order.
already, my lord, I have already deposited the amount, my lord. It is some.
Whatever is there in that order, that's all I'm saying that.
In default, the stay shall automatically stand vacated without further reference to the court, and the award holder shall be at liberty to enforce the award.
My lord, my only submissions, my lord, kindly lordship give me 2 weeks time, lord, instead of 1 week, my lord. It is my humble submissions, my lord. Kindly, my lord, 2 weeks, my lord.
Your Lordship, I appear for the petitioner. Your Lordship has granted liberty to the petitioner to approach the appropriate court in order to execute the matter.
Matter is listed on mentioning. The present matter is taken up on mentioning. The petitioner has sought the return of the original certified copy of the arbitral award dated 19/6/2025, with permission to substitute the same with a photocopy, as the present petition was dismissed for want of territorial jurisdiction, full stop. In view thereof, the department is directed to return the original certified copy of the arbitral award dated 19/6/2025 to the learned counsel for the petitioner, after retaining a photocopy of the same on record. Disposed of it. It's a disposed of matter.
My application, Lord.
Yes.
Of the respondent.
Yes.
Regarding this matter, Your Lordship, I think, and I
Speak in the mic.
I think, and I submit, Your Lordship.
You think and you submit.
Before my learned friend, before Your Lordship, the petition is maintainable or not, Your Lordship, as because when the entire criteria has not been complied, then the petition is not maintainable.
What do you mean the entire criteria has not been complied?
Regarding the question, agreement has been made out, purchase order has been made out, and certain times has been fixed, and in that point of time, the
Section 9, sir, it is about the interim measure which she is asking for.
Non-compliance would be on merit.
Which doesn't stop him.
Then you
But I'll make it very
during the proceeding, after the award, it can be filed at any stage, except before the execution, after the execution of 36.
very great. Just very short facts. The award is given to me of a tender. The tender clause or the agreement provides that if I'm unhappy with the timeline or certain other ingredients of the offer, then or the agreement, I can reach out to them within 7 days. I reach out to them within 7 days and I tell them that what you've given me the timeline to supply is unworkable. No one can do this. So they amend it. They amend the modification with retrospective effect. Then I write to them saying, you anyways, now you've given retrospective effect. You agree that I'm entitled to 2 months more for supply. But by the time they give it, they've taken away that 1 month. So I write to them again. When I write to them again, then they again modify, but resuscitating the first timeline which is there. By then, the timeline is already over. My first period of delivery, let us say, is till November 2025. I write to them. They said, yes, you're entitled to 2 months. So you're entitled to January. But I'm giving it to you from October. You have to give it to me by December. I said, this can't be done. So I write to them. They say, in December, they say, very well, I'm again modifying it. But by now, you have to give it by November. Therefore, you're in breach. We're cancelling it. Before they cancel it, we file an application under 226. When we file the application under 226, there is an order before this Honorable Court. There is an order that they will not take any coercive steps on that basis. Pending that, they come and issue another advice saying whatever general damages apparently that they have suffered, that they are going to recover from me directly. We make that by way of a supplementary affidavit and come before this Honorable Court and say, you again, while this is happening, so the court stays that, passes any order that no steps in respect of that, no coercive steps for recovery will be taken. then the matter is taken up on maintainability and court hears there's an arbitration clause. Because there's an arbitration clause, there are alternative remedies. These are disputed questions of fact emanating strictly from a contract, and therefore I should take recourse. So immediately after that, we file the section 9. But I'll just show one clause and I'll come straight to the point of law, Milord. Your Lordship will kindly have a look at.
So arbitration has been invoked.
No, this is section 9. I will immediately now, we've undertaken, like your Lordship is aware, they have to undertake their invoke arbitration. We've said that we'll invoke arbitration for appointment. If your Lordship desires fit, Milord, here also an arbitrator can be appointed. I'm not so keen to go through a mechanism of section 11, if the railways agree. But I'll tell you, Lordship, why I need the injunction. Kindly have a look at page 85. This is the injunction I'm seeking.
What is it?
This is a cancellation of PO advice this office order. Please have a look at the reason for cancellation, and I'll show one document to show this can't be. Failed to supply, penalty imposed, recovery of general damages of rupees so and so. Remarks is requested to deduct 34 lakhs from the firm's outstanding bills. Because if it's general damages and not liquidated damage under 74, then 73 will apply. If section 73 of the Contract Act applies, then you can't take such a high-handed recourse to recover it from outstanding bills. You also, because there's an arbitration clause, you also have to take the recourse to law. Now, Milord, with regard to failure to supply, I'll just show one document, Milord. I'll come straight to a judgment passed by this Honorable Court that such a clause you can't recover. Milord, please have a look at page 77 once.
Page 77.
77.
Yes.
This is their second modification. Milord, please have a look at the date.
Yes.
27th May 2025.
Yes.
Delivery period, serial number 1. End, it was earlier 16 July 2025. Please have a look at the amendment.
29th April.
29th April.
Yes.
So in May, 27th May, you are telling me what I should have given by 16th of July. You're amending it to make it 29th April. So the day this is issued, I'm in default. Well, what Railways does is it identifies a few people to whom they want to issue these tenders. Once I get through, then they find ways to actually throw out such people. But otherwise, this is unimaginable that on 27th May, you write to me and your Lordship has seen the reason for cancellation is failed to advise, failed to supply. 27th May, I'm already in breach. Before that, the timeline was 16th of July. And please have a look at just immediately at page 77 above the box.
Yes.
Following amendments are hereby issued with immediate effect. So, in May, you're telling me I should have supplied to you what was by July, by April. So, I'm finished. Failed to supply, cancellation advice, recovery of general damages. But I seek no other injunction today. Everything else, my lord, with regard to my damages, wrongful termination, page 77, other documents will actually come in arbitration, and I'm aware of that. I don't want to argue something that's not available to me in law.
What is the writ petition which you had filed?
Writ petition was filed assailing, my lord, this timeline, page 77 and page 75. The writ was actually for seeking specific performance to give me till 16 July. Or the enhanced timeline of 2 months. When the writ was filed, they issued the cancellation advice. Writ was filed in July. The cancellation advice came in August despite an interim order. When the cancellation advice came, the writ court held that now there's nothing else I can do. There's a alternative remedy. You go there and see what you can have. But before that, there was an injunction which was not appealed against. I'll show that to your lordship. Please have a look at, my lord,
Page 91.
page 89.
Yes.
This is 7th of August 2025. Judgment. Petitioners, may I, my lord?
Yes, yes.
Petitioners participated in a tender process, and on being successful, a purchase order was issued in its favor. On mentioning the delivery schedule, the purchase order also mentions a request for amendment may be submitted. The petitioner submitted the request for change of delivery, and repeated communications by and between the parties continued. The petitioners filed the instant writ petition on 25th July, apprehending that the authority may take coercive steps as the date of delivery of such articles expired in the meantime. During the pendency of the instant writ petition, a cancellation advice of 4th August, the petitioners aggrieved. Prayer has been made to permit the petitioners to come up with a subsequent application, and in the meantime restrain the authorities from taking any coercive steps. Leave is granted, stands adjourned. Paragraph 10, respondents are restrained. Lord, I strictly needn't go by this, although from 7th of August till 26th of October, when my writ got dismissed due to alternative remedy, the order was accepted by the respondent. There was no appeal against this order. But if I may just take this point a little further, my lord, with regard to cancellation advice, Lord, may I cite one decision which was found favorably by the division bench of this honorable court? Identical facts, my lord, I had only argued it. My lord, ওনাকে একটা কপি দাও না, 1 minute, sir. The petitioner seeks an injunction restraining the respondent Eastern Railways from proceeding with 3 notices of cancellation of the contract between the parties, and the railways recovering liquidated damages from the petitioner. The subject matter, your lordship will disregard, my lord, because it mentions arbitration clause and all of this. Please have a look at the second paragraph at page 2.
Yes.
The 2 impugn notices are dated 28 July and third is dated 8 July. The reason given for cancellation is failed to supply, and the penalty imposed is recovery of general damages. The petitioner is, however, primarily offended by the remarks portion of the impugn notices, which say that the railways will deduct substantial amount of money from the pending bills of the petitioner and also recover an equivalent amount of 2% of the total value of the unsupplied quantity. The individual figures contain exactly what is there in ours. The fact remains the respondent has imposed general damages and sought to deduct an amount from the pending bills of the petitioner and also recover 3% total value of the quantity which remains to be supplied by the petitioner. The question is whether the railways can do this. Section 73 of the Act, Contract Act, entitles a person who has suffered the consequence of breach of a contract to this will not, therefore that it was stayed. These impugn notices to the extent of imposing penalty at page 4, your lordship will find was stayed, second paragraph at page 4. This is the same interim prayer that I'm seeking. This order stood vacated. From that vacation, we preferred an appeal. And in the appeal, that order vacating this order was set aside. If your lordship desires, I can show that. That's Mukherjee. ইন্টিরিম অর্ডার দিয়েছিল সেটা দেখাও, স্টে ছিল।
Yes.
Yes. Well, this order stood vacated.
Yes.
In a very, anyway. So we preferred an appeal from that vacating. And then your lordship will see 21st May 2024 interim order dated 27th 2023 was vacated. 27 September is what I just placed. that 27 September, it was stayed. Interim order was operative, and this interim order was continued till the final disposal of the appeal.
Yes.
Well, this appeal finally came to be disposed of by appointment of an arbitrator. This appeal, that also, if your lordship desires, I can hand up, Milord. We had only appeared. This really has no bearing on this, but this order was actually never interfered with. Yes, your lordship will see that in terms of the earlier order, somebody was appointed, an arbitrator was appointed, and then the appeal was disposed of. So this 27 September 2023 was actually upheld even in an appeal from a collateral order. The legal principle is just this, not because there is no 74 here. Even if 74, they would have had to prove a loss, but that's another issue. 73, recovery of general damages, if there's an arbitration clause, he is not a higher authority to circumvent the law and just deduct it from my. So that today at ad interim statement, I was only praying for a stay of that particular portion of the cancellation advice. My brief was to seek for a stay of the termination also, but I'm slightly better apprised to not do that today. I'll be praying for a stay of page 85, where regarding imposition of recovery of general damage of 34 from deducting from an outstanding bill.
Yes.
Lordship, as first we come to page number 38, your lordship. The purchase order, your lordship.
Yes, sir. Yes.
Lordship, regarding purchase order, lordship, kindly see 2, 4, 5, 6, 7, 8, 9. Lordship, 9, column number 9, your lordship. New general stores report public KGP 29th March 2025 to 29th April 2022.
Where are you reading? Where are you reading?
Lordship, page number 38, your lordship.
38. Yes.
Block, lordship, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Block number 10, your lordship.
10. Okay. Warranty clause.
Block number 10, SER New General Stores. Lordship, purchase order has been made on 20th March 2025.
All right.
And the date of delivery of the goods.
Yes.
Lordship, between 29th March 2025 to 29th March 2025 to 29th April 2025. Quantity, your lordship, 1,60,000. Quantity.
Yes.
Lordship, the time is fixed. Lordship, regarding this, your lordship, this is the railway clip, your lordship. The holds rail. Railway clip is the vital articles to hold the rail and smoothly the rail going on that point. This is not the general issue, your lordship. This is the issue of the security and safety, your lordship. Purchase order has been made out, and thereafter the petitioner did not fulfill the purchase order and praying before the respondent regarding extension of time, your lordship. Lordship, that is page number 43, your lordship. They are later, petitioners later, your lordship. Lordship, I am read out.
Just a minute.
Section 9, I will not assail the termination. This termination I have not assailed.
Yes.
Lordship, I am traveling the letter in respect to Lordship second paragraph, your Lordship, letters of the second paragraph, since we have to procure raw materials from outside approval sources, we require minimum 30 days mobilization time. Further, for offering raw materials, minimum 15 days time is required, and after clearance of raw material. Lordship, extension of time. Lordship, here, if the urgency is required in respect to safety and security of the country, and the person request and to try to ignore the safety and security of the country, how it can be possible by the respondent to accept their view and proposal, your Lordship. If the acceptance is made out by the respondents, the accident may taken place and a lot of human beings be crushed. Not only that, your Lordship, thereafter another application has been made out by the petitioner to the respondent on page number 44, 9th April 2025, regarding extension. Thereafter, your Lordship, the Railway Board has intimated the petitioner that page number 45. In page number 45, your Lordship, regarding the Railway Board,
Yes.
Railway Board has intimated that as per the guidelines, I am standing on the guidelines, and I am ready to take steps as per the purchase order. Lordship, thereafter, your Lordship, again Railway Board, due to internal circumstances, in page number 61. Page number 61, your Lordship.
Page 45, what were you trying to show? In this page 45, anything in particular?
Lordship, regarding their time has not been accepted by the Railway Board. In page number 61, your Lordship.
Page 61.
61, your Lordship. Railway Board's letter, your Lordship. I am traveling first paragraph of the letter of the Railway Board, your Lordship.
Yes.
With reference to above, it is intimated that PO purchase order number this, dated 25th March 2025, was issued as per your bid dated bid ID number 179666748, dated 18th February 2025, against this railway tender number 60250003, opened on 9th February 2025. In the said offer, you have quoted deviation in the delivery period. Accordingly, tender has been concluded considering your deviation to delivery period, and purchase order is placed. In view of this, the request for modification in the delivery period is not accepted.
Yes.
It is also informed that the ERCS are an integrated component of railway track infrastructure and directly related with the safety of the passenger. The supply as per the purchase order is essentially required. Lordship, thereafter, your Lordship, the internal board meetings of the railway has been taken place.
Yes.
And 1 month extension period has been offered to the petitioner. Lordship, page number 70 of this application, your lordship.
Page number
70, your lordship.
Yes.
Lordship, regarding Lordship, the delivery period has been extended 29th April to 29th March 2025 to 29th April 2025 at the purchase order, the date of delivery of the goods.
Yes.
But in this letter, as per the decision taken by the Railway Board, the date of delivery period has been extended, and that is 29th April 2025 to 16th July 2025.
Yes.
One, column number 1, your lordship. Date has been extended, your lordship. After the extension of the dates of the delivery of the goods, the petitioner did not take any steps in respect to delivery of the goods to the railway, and ultimately the Railway Board taken a decision, and that point of view, your lordship, which my learned friend before submitting just before your lordship, page number 77, that the 16th July to 29th April 2025. Lordship, this is they have submitted regarding the surroundings, that is refixed. Lordship, here refixed means the 29th April previous date has been fixed on 29th April 2025 to that. But here, when the person has not been committed, not been supplied the same, then this and has already ignored the same. As because when the same has already ignored, lordship, I am coming to page number 7, extension of time period by the 885 to page number 60, page number 67, your lordship.
Page number
67, your lordship. Page number 67, your lordship. The petitioner submitted a proposal to the South Eastern Railway in respect to inspection of goods, your lordship. Here, as per the purchase order and as per the contract, your lordship, when the goods has been prepared and the same is to be ready to supply, then it is the duty of the petitioner to intimate the respondent to inspect the goods, that good is as per the standard of this quality or not. But here, your lordship, inspection, and thereafter, your lordship, on page number 68, they have intimated to inspection, and just after the letter of intimation regarding inspection, they have intimated the Railway Board that page number 68, lordship, I am traveling just 1-2 lines. Due to unavoidable circumstances, we are withdrawing our call number this, dated this. We are sorry for inconvenience caused, if any.
Yes.
And in the change of the circumstances, your lordship, the Railway Board has withdrawn the same. My learned friend submitted before your lordship regarding the read petition. One read petition, which
Yes.
your lordship has seen
Page
in the
80.
read petition,
Yes.
page number 106, your lordship. the judgment of the read petition. Lordship has seen one order regarding interim order by the coordinate bench of this honorable court, your lordship, in respect to the later dated page number 8, in respect to the page number 85, your lord. In respect to page number 85, regarding the penalty imposed and recovery of the general damage. In respect to this letter, in the initial stage, the coordinate bench of this honorable court granted interim order, no doubt. But after considering the entire facts, entire views, lordship, the read petition has been dismissed by the coordinate bench. Lordship, page number 162, page number 106 to 113 of this read petition, your lordship.
I don't have page 106 to 113. Second volume.
The second volume.
Yes.
Page number 106 to 113, your lordship. The judgment of this coordinate bench, your lordship. Only the interim order has been granted in respect to page number 85, 4th August 2025's letter, your lordship. On the basis of that letter, if your lordship permit me, then I travel the paragraph number 10 to last of this order.
Yes.
The read petition was filed on July 25th, 2025, and the same was taken up for consideration by the court on August 7th, 2025. On the date of hearing, the petitioners expressed their apprehension that the authority may take coercive action against them for non-delivery of the articles within the stipulated time period and sought for an interim order. In the absence of proper instruction from the railway, the court exercised discretion and passed interim order restraining the respondents from taking any coercive steps against the citizens. A concerned interlocutory application can one was filed by the petitioner on August 4, 2025, enacting the communication dated August 4, 2025, paragraph number 11, whereby the petitioners were intimated regarding cancellation of the purchase order and the penal action that was sought to be taken. Today, at the time of final hearing of the read petition, it has been submitted that if the initial modification service dated May 2nd, 2025 is accepted by the court, then the subsequent modification advice dated May 27th, 2025, cancellation order dated August 4, 2025, and the penal action sought to be taken by communication dated August 4, 2025 will all fall flat. It has been submitted that if adequate time is allowed to the petitioner, then they are still willing to supply the materials. Prayer has been made to set aside the modification advice dated this, cancellation order dated this, and the communication dated this, seeking penal action against the petitioner. Prayer has to be also been made to modify and reflect the delivery period stipulated in the purchase order dated March 20th, 2025. Lordship, this paragraph clearly, boldly speaks that after considering the letter dated 4th August 2025, the writ petition has been dismissed, Your Lordship. Paragraph number 16, Your Lordship, the court, after hearing the parties, has posed the question before the petitioner to safety with regard to maintainability of the writ petition, as the same relates to the contractual disputes in between the parties. Lordship, they have submitted their judgments. Paragraph number 18, the court has pursued the documents annexed to the writ petition. It appears that the initial time period as mentioned in the passage order for delivery of the first batch of the time from 29th March 2025 till April 29th, 2025. The authority has itself intimated the petitioner that the timeline was being extended considering the willingness of the petitioners to deliver the article. Thereafter, the action of the petitioners raised doubts in the mind of the authority with regard to the genuineness of the petitioners to supply the articles. The authority repeatedly intimated the petitioner that the articles were essentially required and not supply of the same would jeopardize maintenance of work related to track safety. The petitioners were time and again put the notice that instead of execution of supply, they sought to incorporate phase condition in the contract. The initial time period within which the item was to be delivered was 30 days. The petitioner repeatedly sought for extension of time for supply of the articles. The authority initially thought it fit to extend the time period, but thereafter, considering the conduct of the petitioners, revoked the extension and decided to strike to initial time period for the delivery of the articles. The question has been raised by my learned friend regarding already mentioned in this judgment also, and it is considered, Your Lordship, by the writ court. The authority has considered several factual aspects, namely the conduct of the petitioners after issuance of the passage order, repeated requests made by the petitioners for extension of time period for supply of the articles, the inspection notice given by the petitioners, and intimate revocation of the inspection notice, and has come to a conclusion to cancel the purchase order and initiate penal action against them. Lordship, it will be highly improper for the writ court to adjudicate whether the extension of time and thereafter revocation of the same for supply of the articles, which are extremely vital and essential for maintenance of the work related to track safety, is proper or not. The railway are the best authority to decide. Lordship, here court finds out that the railways are the best authority to decide within which period the articles which are so very vital for the safety of the passengers and maintenance of track safety is required to be supplied. The writ court is not the proper forum to direct the authority to extend the time period for supply of essential articles. Supply such contractual disputes ought not to be entertained by the writ court. The court does not find that there has been violation of any constitutional provision or culpable illegality or arbitrariness on the part of the authority requiring interference by the writ court. In view of the above, writ petition fails and is hereby dismissed. Lordship, entire points has been considered by the writ court and ultimately the writ petition has been dismissed. In this respect, Your Lordship, my humble submission before Your Lordship, again, the same self-question has been raised in respect to the letter dated 4th August 2025 by the petitioner. So far, my knowledge, Your Lordship, and my submission before Your Lordship, the same is not tenable. As because when agreement has been made out by and between the parties, time has been framed by and between the parties, and the time schedule is in respect to the safety and security of the social. In that respect, if the panel action has not been taken by the authority, then the each and every person taken advantage or disadvantage of that issues. No doubt, the A has committed fraud and A has committed offense and or A has committed disobedience in respect of that questions, that parts, and the court has removed them to entire liabilities. Then we also try to take that routes. She also try to take that routes, and where the scope of this same taken ends. So it is necessary to take a point and view, your lordship, that some situation and some place where the route ends. In that respect, your lordship, I submit before your lordship, dismiss the application, your lordship, as because, your lordship, one thing, your lordship, in my schooling period, your lordship, I have learned one sentence. Sympathy is used whether the scope is there, if it is necessary, if it is for the universe or for the socials, but not in part of the single, where single beneficiary is there. In that aspect, your lordship, I am submitting before your lordship that kindly dismiss the application. That's all.
Could I?
Yes.
Yes. Could I just respond to that? Firstly, there is no allegation that I have caused an offense or some fraud. It's a simpliciter contract. There appears to be a breach of the contract. Cancellation or termination is not my issue in the Section 9 code. I'm going to take it up in the arbitration. Prima facie, what I wanted to show, he's relied on 3 documents. 8th of May 2025, I write to them that please extend. He's relied on that. Your lordship looks at page 70. The writ court I'll come to later because there I lost on maintainability. This is my forum. Please have a look at page 71.
Yes.
These allegations from the bar that I have not, page 70, your lordship will see date is 16th of May. I am giving time.
Mr. Banerjee, that's a wrong submission to the extent that 16th of May, this letter which you're showing,
yes,
the initial cutoff dates which
yes,
are given
was till 29th of April.
Correct.
Well, there is a clause in the contract
term of
which
the contract.
understandably was not shown to your lordship. Please come back to which one. Why did they intimate it, increase it? I'll show that. Please have a look at, that particular clause here, which your lordship will find. Page 39, please see.
Yes.
This completion period was 29th of April. Now, you please have a look at clause 16 once.
Yes.
Note 1. Request for amendment of those purchase orders that are available in so and so under contract shall be submitted through IREPS only. 2. If any conditional clause in this document is not as per the offer of the firm, the same should be represented within 7 working days, failing which it will be deemed unconditional acceptance. So because this was not in terms of what we had given, within 7 working days, we write to them saying, I will not be able to supply. Please extend the timeline. That letter my learned friend relies on. And your lordship will now have a look at page 70. Relying on my request, what do they do? This is not a case where I could have understood if clause 16 had not been there. 16 only gives them the power and me the right to write to them saying, please extend, because this is not in terms of the offer. I want a certain period. Page 70, please see.
Yes.
16th of May, based on my request. Delivery period was 29th April, as my learned friend had shown. This is extended till 16th of July, as per my request. So 16th of May to till 16th of July, I could have given the first tranche. This date is important. Lordship will please have a look at now, page 77. Just hold the two side by side note if it's possible. So 16th of May, time given till 16th of July, 2 months. 27th of May, 11 days later, the time is made from 16th of July to 29th of April. I'm in breach, I'm finished. So there is nothing in between. In 11 days time, the first period is revived. Now, in these facts, we come up. In the writ, we wanted a specific performance of the contract to say. Now that I've lost the writ, I can say what I really wanted there. We wanted a specific performance by extension of these timelines. While the writ was pending, they issued this cancellation advice. When the cancellation advice came, your Lordship has seen, the writ court holds that these are contractual disputes, palpable Article 14, because we had shown Subodh Agarwal and MP Power and all of that. Said palpable Article 14 violation, I don't see. Contractual dispute, you have an arbitration clause, go there. This is my forum to actually urge this. And my forum is actually not even here. It's the arbitration. Pending arbitration, I have come up before your Lordship saying this cancellation advice, and legally, there has been no answer to page 85. My short issue before in the section 9 court is that this kind of recovery of general damages from an outstanding bill is impermissible in law. But if they can show any repository or any, because under 73, there are twin tests. There has to be a breach. That breach must have occurred a loss. That loss must have arisen naturally in the usual course of things from that breach. That's the test, which is why the single judge's decision, my lord, that unless there is a loss, there can't be a simpliciter case of recovery. And legal aspect of it, there has been no reply. The breach, specific performance will be my case. Contrary will be damages alternatively. His case will be, that will be in the arbitration. At the injunction, while that is there, this kind of recovery and deduction from my outstanding bills has been already held by this court to be something that the railways can't do, which has now been affirmed in a way by the appellate, by the division bench. I am only seeking a stay. In my section 9, your Lordship will see, there are no reliefs, that timeline be extended. So I needn't trouble your Lordship with that. I understand that that's available to me in the arbitration. And now I have to challenge the cancellation advice and then seek specific performance in the alternative case for damages for wrongful termination. Pending that in the section 9, it's only this, that you can't recover it from outstanding bills because this does not fit in section 73. That is all. That is all so at the ad interim stage, if they want to file an affidavit, something else, at the ad interim stage, I'll be seeking your Lordship to give a stay of this recovery from outstanding bills. Second, one more aspect, August 2025, there was similar stay part by the writ court. Till October 2025, till the matter was rejected because of the arbitration clause, they had not preferred an appeal. So that obviously did not hurt them. So if they, I don't know what my learned friend is seeking, if he wants to file an affidavit or he seeks a dismissal today, I don't know. But the Lordship will kindly consider the stay of page 85, either for affidavits or before it goes to arbitration.
The issue has to be decided in the arbitration.
I'm sorry, Milan.
The issue of recovery shall be decided in the arbitration.
Yes, till then let them not recover it from outstanding bills. Then I will have to, that is the issue. Your Lordship is, if they recover it from my outstanding bills, I have to make a suit for recovery of money. Because then it will be a decree for a sum of so and so as wrongfully recovered from the plaintiff. Whether they can recover or whether I am liable to pay,
that will be
decided in the arbitration. Pending that, and may I also beseech your Lordship to appoint an arbitrator here and now.
I can't do that.
But if he gives consent, we can. I don't have to come back, file another 11. And your Lordship is absolutely right. This issue of recovery, this is what has been held by the judgment.
Yes.
1 minute's reply, your Lordship.
See, one thing is there's a demand which you have raised. Whether that is right or wrong, that will be decided by the arbitrator. In the meantime, the protection has to be there to them. Otherwise,
Lordship,
the entire contract and the arbitration proceedings is
gone.
A nullity.
Lordship, your Lordship.
It's a bill, outstanding bill. Deduction.
Yes.
Restraining the respondent.
Sorry?
Restraining the respondent.
Yes.
If your Lordship granting ad interim order
Yes.
in respect of the letter dated 4th August
Yes.
2025,
Yes.
Lordship, your respondent will be suffer irreparable loss and injury.
Not at all.
Where, your Lordship, I am submitting
Yes.
your Lordship. Just, your Lordship, allow me
Yes.
1 minute's time.
Yes.
Lordship, my learned friend submitted before Lordship regarding loss.
Yes.
Respondent suffered a huge loss, your Lordship, as because when the quantity has not been provided as per the
Prove
standard.
your loss before the arbitrator, get the money recovered.
Lordship, thereafter, your Lordship, kindly regarding restraining, Lordship, this.
It has to be restrained. What is the point of filing this section
Lordship,
9?
when the prima facie has been established, here, your Lordship, prima facie has not been established, your Lordship.
That is for me to decide, not for you. All right. Anything else? All right. Take down.
Lordship, regarding page number 1, your Lordship.
Yes.
Lordship, my learned friend submitted before your Lordship page number 39, paragraph number 16. In that point, your Lordship replies paragraph number page number 39, paragraph number 6, your Lordship. Security deposit SD. Security deposit is waived being RDSO approved for this item. Railway reserves the right to cancel the purchase order or letter of acceptance and recover an amount. Lordship, already it is mentioned in paragraph number 6, your Lordship, that the railway board has right to recover that, your Lordship, amount equal to SD value of this percent of as a general damages from this contract or any other contract of the firm in case of failure of firm in execution of the contract, your Lordship. Lordship, as per the terms, your Lordship, as per the terms of the purchase order, your Lordship, I have taken steps, your Lordship. So where is the prima facie available, your Lordship?
All right. Take down. The petitioner has filed the present application. The petitioner has filed the present application under Section 9 of the Arbitration and Conciliation Act 1996, seeking an order of restraint against the respondent from giving effect to or recovering, deducting or adjusting, any amount towards damages as claimed by the respondent in the cancellation advice and recovery notice dated 14/8/2025. Full stop. No, for 4th August. 4th August is the,
Yes,
sorry, 4th August 2025. 4th August 2025.
but
It is the case of the petitioner.
my junior is here, Mr. Dasgupta.
It is the case of the petitioner that the respondent issued purchase order dated 28/3/2025 for manufacture and supply of elastic rail clip MK-V5 with flat toe. यहाँ से ले लेना ये 106 MK flat toe flat toe for 60 kg / 52 kg rail section to RSDO DRG number T5919 / alternate 2 or latest with IRS specification number T-31-2021 fifth revision full stop. Fifth revision full stop. यहीं कर देना IRS स्पेसिफिकेशन नंबर सो एंड सो T21 यहीं पे कर दो, फिफ्थ रिवीजन पे छोड़ दो, ठीक है, यहाँ तक डालो. The petitioner submits that it has only one manual MPI unit with monthly production manual unit. MPI manual unit, M capital P capital I unit with monthly production capacity of 1,08,000 units. 1,08,000 units as approved by the RDSO, full stop. The petitioner asserts that it cannot exceed the said approved capacity, full stop. However, under the purchase order, the respondent stipulated a delivery quantity of 1,60,000 units within 1 month from the date of issuance of the purchase order. Since the stipulated quantity exceeded the petitioner's production capacity, the petitioner represented the extension represented for the extension to the respondent, full stop. Extension of supply of the product to the respondent, full stop. The respondent thereafter received the extension of the time period for the supply. Extension. The respondent thereafter revised the purchase order twice, however, on both occasions, the revised quantities continued to remain beyond the petitioner's production capacity, full stop. Aggrieved thereby, the first writ petition was filed on the ground of.
But on the ground of arbitrariness in going back to the original delivery period.
All right. Aggrieved thereby the which is that letter which on which you had.
But page 77 is the modification, and the supporting letter is at page 73.
This is what you had challenged?
Yes, this is what we had challenged.
Agreed by the communication dated 28/5/2025, wherein the extension of the delivery period was modified. The petitioner filed a writ petition bearing number 16985 of 2025, challenging the delivery schedule fixed by the respondent, full stop. During the pendency of the writ petition, the respondent issued a cancellation advice dated 4/8/2025, cancelling the purchase order and imposing a penalty of general damages amounting to rupees 34,70,144, full stop. This court-wide order dated 7/8/2025 in the writ petition was pleased to restrain the respondent from taking any steps for recovery of the said damages as mentioned in the cancellation advice dated 4/8/2025, full stop. The said interim order remained operative till it was till 27/10, right?
Yes, yes.
27/10/2025, when the writ petition was dismissed on that day, right?
Yes, on
when
that
the
day it
writ
was
petition was dismissed, granting liberty to the petitioner to approach the appropriate forum in accordance with law, full stop. The petitioner submits that there exists an arbitration clause in the purchase order dated 28/3/2025, incorporating the IRS condition of contract 2022, it is desirous of, the petitioner states that he is desirous of invoking arbitration, full stop. However, pending such invocation and adjudication of the dispute before the arbitral tribunal, the petitioner seeks an order of restraint against the respondent from taking any coercive steps for recovery of the general damages as indicated in the cancellation advice dated 4/8/2025, full stop. Learned counsel for the petitioner contends that the dispute between the parties are arbitrable and are to be adjudicated by the arbitral tribunal, full stop. However, if during the pendency of the said adjudication the respondent is permitted to recover the said amount of general damages, the petitioner would suffer irreparable loss and injury which cannot be compensated in terms of money, full stop. Learned counsel for the respondent states that the present application is not maintainable since the petitioner has failed to comply by the terms of the contract, full stop. To buttress his argument, he states that the petitioner has failed to abide by the timeline which was provided in the contract for supply of the it's a equipment or a
elastic rail pips.
Supply of the material.
Yes,
Supply of the material. Full stop. He states that the petitioner, since the very beginning, had the intention of not complying with the purchase order and thus had sought for an extension of the time to supply the said material. Full stop. He further states that the equipment, the material to be supplied by the petitioner is of great importance since it relates to the safety measures of the railway and the non-supply would have caused grave prejudice to the respondent. Full stop. Learned counsel for the respondent further states that the the claim of damages and recovery is in terms of the contract, and that the petitioner and that the present application shall not be entertained. Full stop. Anything else, sir?
So I have submitted. That's
it.
As because the purchase order of 28th March 2025, paragraph number 6 boldly speaks regarding that.
Learned counsel for the petitioner to support his to support his contention. Learned counsel for the respondent relies on clause 6, column 6 of the purchase order, wherein it is stipulated the time period for the supply of the materials are stipulated, and that any breach of the same would incur damages on the petitioner. Full stop. On the petitioner. Full stop. This court has heard the arguments advanced by the counsel for the parties and has perused the materials on record. Full stop. It is not in dispute that an interim protection had earlier been granted to the petitioner in the writ petition till 27/10/2025 during the pendency of the writ petition. Full stop. The said writ petition came to be dismissed and the stay order was vacated stay order was vacated. Full stop. Consequently, the controversy between the parties with regard to the alleged breach of the purchase order and the imposition of general damages is yet to be adjudicated by the appropriate forum in terms of the contract, i.e., the arbitration clause. Full stop. Prima facie, this court finds that the dispute between the parties arise out of a contractual agreement containing an arbitration clause incorporating the IRS condition of contract 2022. Full stop. The petitioner has expressed his intention to invoke the arbitration proceedings, and therefore the matter is squarely covered within the scope of Section 9 of the Arbitration and Conciliation Act 1996. Full stop. Considering the alleged demand raised by the respondent, considering that the alleged demand raised by the respondent pertains to general damages, which can be finally determined only after adjudication by the arbitral tribunal, the recovery, of such amount at this stage would cause undue hardship and prejudice to the petitioner. Full stop. This court is further of the view that the petitioner has made out a prima facie case warranting protection. Full stop. The balance of convenience. The balance of convenience also lies in favor of the petitioner, since the respondent, being a government entity, will not suffer any irreparable prejudice if recovery is delayed pending the arbitration proceedings. Full stop. Pending the arbitration proceedings. Full stop. On the contrary, if the respondent is permitted to effect recovery, before adjudication, the petitioner would suffer irreparable loss and disruption of business operation, which would amount to irreparable injury. Full stop. In view of the aforesaid circumstances, this court finds that the respondent shall remain restrained from taking any coercive steps to recover the general damages as mentioned in the cancellation advice dated 4/8/2025 for a period of 8 weeks. In the meanwhile, the petitioner is directed to take immediate steps for initiation of the arbitral proceedings in accordance with the arbitration clause contained in the purchase order dated 28th of March 2025. Within 10 days?
Yes, Manoj, we shall.
And report compliance before this court within 2 weeks.
Or sorry, Lordship, regarding Lordship has dictated that regarding IRC standard condition of contract, Your Lordship. Lordship, regarding point number 702 of the contract, Your Lordship, page number 125 of this read petition, Your Lordship, page 702, paragraph number.
Sir, I'm not concluding your contract. Your entire issue is left open to be decided by the arbitrator. I'm not deciding your contract right now, whether your damages are rightly put, wrongly put. All this will be decided in the arbitration proceedings.
Lordship, kindly mention.
This is only section 9.
This Lordship submission in the order sheet, Your Lordship.
What submission?
Lordship, point number 702 of the IRC.
Yes, page
number 125, Your Lordship.
Yes, what is it?
Lordship, paragraph 702 of the agreement, Your Lordship, empowers the respondent to take measures, Your Lordship.
So who's stopping you? Am I saying anything regarding whether you have the right to recover or not? I'm not deciding the issue, sir. This is a section 9. I hope you understand the scope of section 9.
Lordship, at least this.
Why should I get into the merit of the matter? Why should I comment
Lordship
anything?
is restraining me to, and due to that, Your Lordship,
I'm only restraining you till the time the adjudication proceedings start. And this section 9 gets converted into 17, and he will say whatever he has to before the arbitrator. And that's why I'm fixing a timeline of 2 weeks. If he doesn't do it, I'll vacate the stay also.
But one more thing, if I may add, that can it takes by prayers, prayer B or D, if Your Lordship could consider, because what is happening is because of
only general damages, nothing.
Yes, this is on general damages only. But what the railways is doing, they are not accepting my bills, saying that these are lesser than the amount which is to be recovered.
Invoke the arbitration.
That I'll have to.
Nothing more.
Very well.
Returnable 2 weeks. You
Yes,
take action.
yes, Madam. I shall take steps.
All right. Keep it
Grateful,
after 2.
grateful.
In the meanwhile, you want to file your reply?
Lordship, direct me then.
There's no need. Let them do it. Otherwise, I'll vacate the stay. I'm not deciding the issue against you, sir. Don't have that thing that I'm deciding the issue. It is just that.
Has been disposed of.
No, I'm keeping it for compliance because they should take steps after 2 weeks.
Your Lordship, direct me then, Your Lordship.
After 2 weeks. Come after 2.
Grateful, grateful.
I'll come back after 5.
Malad, this is my application, Malad, seeking extension of the mandate, Malad. This is for the second time, Malad, I am filing this, Malad, section 29A application.
Any objection?
No, my lord, I have no objection.
Give the dates.
Malad, the pleadings were completed, Malad, on 15th of May 2023, Malad. Malad,
15th of
thereafter,
May.
Malad, on 15th May,
When was the arbitrator appointed?
Malad, on 14th of October 2022. There's a 3 members tribunal, Malad.
Okay.
Malad, thereafter, Malad, in terms of section 29A1, Malad, the 1 year has ended, Malad, on 15th May 2024, Malad. Thereafter, Malad, on consent, Malad, in terms of section 29A3, Malad, 6 years have been extended, Malad. Thereafter, Malad, on Malad, in the month of November, Malad. Thereafter, Malad, we preferred, Malad, the application, Malad, on 29A on at page 56, Malad, the order. The 29A application was taken up on 21st of November 2024.
APCOM 939.
939, Malad. Malad, by an order dated 21st November 2024, Malad, it was further extended, Malad.
1 year.
For
1 year. And thereafter, Malad, we communicated the order to the learned tribunal, Malad. Malad will find it at next page at page 58.
Page 50.
8, Malad. We communicated the order to the learned tribunal, Malad. At page 58, Malad, relevant part starts from page 59. Malad, the tribunal has considered, Malad, and the period, Malad, extended till 22nd of November 2025. Malad will find it at page 60.
All right.
May I read, Malad?
I got it. Take down. The present application, the petitioner has preferred the present application under section 29A of the Arbitration and Conciliation Act, seeking extension of time, conclusion of the arbitral proceedings and publication of the award. Full stop. Learned counsel for the petitioner submits that the parties, by mutual consent, constituted the arbitral tribunal, which entered upon the reference on 14/10/2022. Full stop. This court, wide order dated 24/11/2024, passed in APCOM 939 of 2024, extended the mandate of the arbitral tribunal by a further period of 1 year from the date of communication of the said order to the tribunal. Full stop. Consequently, the present mandate of the tribunal is due to expire on 22/11/2025. Full stop. It is stated that the arbitral proceedings have reached the stage of final arguments and therefore, the petitioner has preferred the present application seeking further extension of the tribunal's mandate. Full stop. Upon perusal of the record, it appears that the arbitral tribunal has conducted more than 46 hearings and has recorded extensive evidence on behalf of both the parties. Full stop. The proceedings are now at the stage of final arguments. Full stop. Learned counsel for the respondent states that he has no objection to the present application and that the mandate of the tribunal can be further extended. Full stop. Upon consideration, this court is satisfied that there has been no undue or unwarranted delay in the conduct of the arbitral proceedings and that sufficient progress has been made by the arbitral tribunal in expeditiously handling the matter. Full stop. Accordingly, the mandate of the arbitral tribunal is hereby extended further for a period of
1 year.
1 year.
Yes,
1 year from today. Full stop. The arbitral tribunal is requested to ensure that the arbitral proceedings are concluded and that the award is published within the extended time period without seeking any further extension. With the full stop. With the aforesaid observation and direction, the present petition stands disposed of.
My lord,
Why
only
1
thing,
year? 8 months you can finish it off with
My lord,
final argument stage.
my lord, that's my lord, I want to indicate, my lord. My lord, we have filed, my lord, during the stage of, my lord, the argument, we had, my lord, filed the section 17 application, my lord, for further interim protection, my lord.
No, that's all right.
My lord,
Section
that's it's, my lord,
8
that is
months.
pending, my lord. My lord, it is
Today.
recorded, my lord.
8 months, 8 months.
So, my lord, kindly keep it, my lord, for 1 year, my lord.
No, 8 months is perfectly fine.
My lord, only thing, my lord, 17 application, my lord, is
Section
pending, my
17
lord. The affidavits have not yet completed, my lord.
That's all right.
My lord, that has to be, my lord, heard thereafter, my lord.
That's all right.
My lord, only thing, my lord, since no affidavit is being filed, my lord, the allegations are not admitted in this application. My lord, there are allegations against my client. My lord,
None of
if
the
one line can be.
mistake. This is not admitted at all. This is just for the extension. What allegation?
My lord, on affidavit, my lord, there are allegations. So that's why I said, my lord, that if one line can be
No
added.
affidavits have been exchanged. None of the allegations are admitted. No direction has been passed for the exchange of the affidavit. None of the allegations are admitted. All right. Next.
Obliged.
Lord, I'm appearing for the petitioner.
Can we hear it now? We should go before. Item 7, can we start it now? You know, because I
my application. Let me start, my lord. My application, it was adjourned for the last time also Lordship asked us to give them, my lord, a notice. We have given it to them, my lord. 8. But this is a very simple application, my lord, whereby, my lord, the amount which has been secured for obtaining a stay under 36(2) is to be released. Now, my lord, this is settled law. I have to give a bank guarantee, my lord, or a cash security, whatever Lordship pleases with the registrar to keep it secured, and I can take the money out. Because he'll be secured by the bank guarantee of the equivalent amount that I am giving. So that's a simple application for that. No allegations, no facts, nothing at all. An award was passed, my lord, by the arbitrator, my lord, on, my lord, January 2020. Against that, they preferred a section 34, which is pending. When we filed an execution, since there was no stay, they came up with a 36(2) by securing the entire amount. Now, my lord, the law is well settled, my lord. There's a division bench judgment of this court, Supreme Court judgments also saying that during the interim period till the matter is heard out, the, my lord, award holder can secure the exact amount and take out the money for its business purposes and other purposes. So that is exactly what I'm asking for. Simple prayer.
Who's there on the other side?
My lord, I'm led by Mr. Bagh.
I have 2 judgments. If your lordship wants, I can
Passover.
give it more. Well, this is the
Where is
Calcutta
he?
High Court
He's
judgment.
on like he's on his legs, my lord. I'm praying for a short Passover.
Let me see the judge.
This judgment of our High Court, my lord, considers all the Supreme Court judgments also. And, my lord, it, my lord, categorically states that there is no prejudice cause because I'm going to secure the entire amount with the registrar as he has done. So he cannot say that he is prejudiced, my lord. हमारी कौन मामला আমাদের যে প্যারাগ্রাফটাতে বলেছো তুমি সাফার করছো সেটা বার করো
ডিমান্ড পাই গেল পেজ 44 ডিমান্ড করেছে আমার কাছে টাকা 34
হ্যাঁ তুমি যে দিতে পারছো না সেটা প্লিডিং আছে তো তুমি সেটা বলো কোথায় আছে
হ্যাঁ
এটু
কোন প্যারাগ্রাফে বলেছো বলো? নিশ্চয়ই বলেছো। নিশ্চয়ই আছে, দেখো প্যারাগ্রাফে। হিডিং এ বলো না কেন? তুমি তো লিখেছো। হ্যাঁ নিশ্চয়ই বলে আছে। এটা এক্সিকিউশন দেখছি আমি। A2 টা দেয়নি আমার। হ্যারিফুল হাঁকের জায়গায় হালদার হয়ে গেছে।
वही मैटर है नहीं हरिपुर হালদার বলো হালদার হয়ে গেছে না হালদার হ্যাঁ জি এর অপোজিশন পেয়েছিলেন হ্যাঁ পেয়েছি পেয়েছি লিখে দিতে হবে
No, but this is a different thing altogether, Mr. Banerjee.
Yes.
This is you are securing.
Yes.
Any modification of the order can't be done like this.
No modification.
It is modification.
No, my lord. What is
How
happening?
can it not be a modification?
No,
When you have been asked to furnish this amount and you're going to replace it by a bank guarantee, this is modification.
No, my lord. Perhaps, lordship, I'm sorry, my lord. What has happened is that, my lord, I have not put in any money.
All right. Who has put in the money?
He has put in. He is the judgment debtor, the award debtor. He is put in the money. The Supreme Court and the courts across say since the 36(2) gives a stay, therefore, my lord, these 34s are pending for 20 years, 30 years. So the decree holder cannot suffer. At the same time, my lord, the decree holder should not steal a march. Therefore, my lord, he has to secure the entire amount with the registrar and take out the money. That is exactly I'm asking for. And that is exactly what this judgment also dealing with all the Supreme Court and High Court judgment says. You secure by bank guarantee and take the money. Nobody is prejudiced.
So you are the decree holder.
I am the decree holder. I want to, my lord, he has put in 50 lakhs. I want to put in equivalent amount of bank guarantee because my business is prejudiced. I have, my lord, quoted that in my pleadings and I want to take out the money. So no prejudice is caused, my lord.
And that
is the only simple prayer.
That is I
No, my lord. I am not going to ask for a modification.
maybe that is permissible.
Yes, that is exactly what the courts have said because 34s are not heard out, my lord.
That is permissible,
Yes.
but I thought it's the other way
No,
around where you
not
are
at all, my lord.
and you are trying to modify the order. That
I'm going to secure the entire amount, whatever the registrar has,
Where is the
and take
senior?
it out.
My lord, may I file the opposition, my lord? He's coming, my lord.
Where is your senior?
He's coming, my lord. Yes.
Opposition কি বলেছে?
You have been supplied a copy?
Yes, I have got a copy, my lord. Kindly sees the opposition that he has filed. What is his contention, my lord? He says that, my lord, the 36(2) is misunderstood and misinterpreted. I don't think, my lord, that is so. His stay will remain. And, my lord, his amount will also remain. I'm going to furnish it together. Then
We'll
he see.
All right, we'll have it on Monday then.
Very well,
He's not there. I don't want to prejudice the young boy.
No, not at all, my lord. Not at all.
I'm grateful, my lord.
Monday. Just take down.
শুধু অ্যাপিয়ার করে গেছে ওরা হ্যাঁ নাও
Affidavit in opposition on behalf of the respondent. Why judgment debtor. On behalf of the judgment debtor is taken on record. What is that?
Your Lordship, this is the 34 main matter, the 34 reply we are filing.
Reply to the main petition.
34 is taken up today. Is it?
No, 34 is not there, my lord. 34 is not there. This এটা আমরা কপিও পাইনি
We'll take up the 34. Is there in the list?
Yes, lordship can take it out.
Which
more.
item?
And it's
Just
AP number 196 of 2020.
This is 7. It is the 34 or this is the IA? Acha, okay. All right. Just give AP number so and so and IA में ये लिख लेना. That reply affidavit
196 of 2020.
filed by the judgment data is taken on record.
हाँ.
और AP में लिख लेना. Yes, give me. The reply filed by the judgment data is taken.
Although this is not been served, but I take it that my learned junior friend will serve on me.
I apologize, my lord.
It is,
It's on legs.
Oh, that's okay. Catch your breath. You want it today, you want it on Monday.
So there's a application 36.2. That, my lord, can be disposed of. I'll indicate why, my lord. Paragraph.
We'll dispose of everything. Why only
9.
32?
Well, the
36
section 34 can be heard out, my lord. The lordship places it on Monday. We'll argue the section 34. I'll indicate why, my lord. Kindly see paragraph 9.
Let's start hearing it today.
We're ready, my lord. It's just that I'm being led by Mr. Bose, Mr. Tilak Bose in the matter, and he insists that he will argue the section 30. But we want him to argue, my lord, to lead the team in section 34. Section 36.2, my lord. This has come up suddenly. The 36.2, is the prayer. I'm only praying if the 34 is taken up, then this becomes, my lord, the urgency. There's an urgency indicated there. That since the section 34 is not being heard out, that's the urgency, hence the prayer is made. Now, when the section 34 is not taken up for hearing,
Why 36.2 is not maintainable according to you? What is the difficulty?
There's no longer an urgency, my lord. Kindly see. It's already been secured by us. Now, my lord, it's a bank guarantee which we have given. They want to encash it on the premise after 3 years, my lord, on the premise that section 34 has been pending for long. If it's fixed, my lord, together. then,
I
my lord,
don't
this-
think, Mala, that is the cause. The cause is at paragraph 11 of my petition, whereby, according to the judgments and the law, I'm entitled to take it out because I'm suffering in my
But
business.
they've also indicated, my lord, can you see paragraph 9? I'm right in the paragraph. My lord, kindly see paragraph 9, page 5. It's manifest from the records that the applicant has not taken any steps to get the matter expeditiously heard at any time after the passing of the award. It's pertinent to mention herein that the pleadings in respect 34 complete long time back, no steps to get 34 heard, shows clear malafide. That's the premise.
I have
You're
two
having the 34
premises.
heard,
I
my
have
lord.
two premises, and I'm not wrong. Lordship is taking it up. It's pending from 2023.
Also, paragraph 11, we already state, my lord, they said that the award has been secured by 50 lakhs bank guarantee in 2021. We are in 25. Pandemic, my lord, the next page, over the page, page 6. Applicant has availed certain credit facilities. Due to pandemic, they suffer a loss, received around 34 odd lakhs from the firm Ashok Construction. And that's why, my lord, they say, paragraph 12 seeks direction for additional bank guarantee of 50 lakhs. 34 is on board, my lord. Kindly hear out the 34.
So there
We have
is
a
no
good case on
objection
merits.
from my
that's
my
my
learned
objection.
friend's
Because
end.
the
He cannot
point
have
that
an
they've
objection
taken-
that I furnish the entire amount and take it out. He cannot have an objection to that.
No, but there's a prayer, my lord, paragraph 12 for additional bank guarantee of 50
I'm not
lakhs.
asking. I'm not asking. I'm not pressing it.
So
Lordship can
today, my lord,
record.
since we are on Tuesday, if you're if we are on
He's not
Wednesday,
pressing it. Suppose I'm not hearing 34, because
My
there are a lot of 34s which are there.
my lord,
The application can be allowed. What
but
is the
kindly don't, I'll indicate why. My lord, kindly see, there's a bank guarantee which we have, through which we have secured this in paragraph 11. That's what they've stated.
Right.
Now, my lord, if they want to encash this bank guarantee, that's paragraph 14.
Yes.
Where, my lord, they want to encash this bank guarantee.
And secured it.
Yes.
They'll secure
Entire
it.
amount I'll secure.
If they
With
want
the
to secure
registrar.
the entire amount, sounds like you should be there, sir.
That's the rule. That's the law.
I can't really oppose. That's why I'm taking instruction, because there's
So
a
that order can be
government entity
passed.
that I have to take that instruction.
That's what it is.
We don't have a difficulty, my lord.
So that order can
If
be
that's
passed.
secured, it is secured. That's all
Obviously,
that we
Mala, that's
want.
my prayer. Lordship can record it. Entirely I will secure.
The 34, the records and all are here.
I don't know, my lord.
My lord,
In 34, the records are here. Records are here. So let's Monday.
Monday, my
very
lord.
deep privilege, my lord.
Get a copy of the opposition.
And I apologize, my lord, for not being
Reply.
when the matter was called.
At the request of the parties, let this matter be listed on Monday.
I know, that's why.
Now both the matter. Bole AP number bole diyechen Lordship. Grateful, my lord.
Affidavit of reply filed by the judgment debtor is taken.
What করে নেব? কোনো চাপ নেই। যা আছে সব দিয়ে দেবো।
Try to hear it. Let's see if we can. We'll see on Monday. Otherwise, we'll allow the application.
Yes, Lordship. Grateful.
Very deep privilege, my lord.
এগুলো দেবো। My lord, this, my lord, Lordship had said, if they do not appear, then Lordship will, my lord, dismiss for default. My lord, this is a section 34, my lord, pending for long time. My lord, item number 9 and 10.
9, 10, anybody there? None for the petitioner, dismiss the default. I think then only people will come.
Yes, if they come, my lord, if they restore it, we'll again, my lord. We have served also, my lord, so this can be kept on the record. Since lordship said to serve on them, we have given
Yes.
a notice also that it would be taken up today, my lord. Eleven, 12 tag. 11 and 12, same situation, my lord. They all appeared on the same day.
Same. 11, you're there?
My lord, I appear for 13 to 17, my lord. The next series.
Wait. 11, 12, dismiss the default.
এটা তো রাজি হয়ে যেতে পারে। হ্যাঁ, এটাতে কি arbitrator আছে?
Yes, now 13 to?
But 13 to 17, my lord, I appear for the petitioner.
Yes.
And my instruction are that, my lord, the matter has been settled, my lord, and this has become infructuous, my lord, these 34 applications. My lord will kindly dismiss this as infructuous, my lord.
No, but you have to make a statement. You are the advocate on record.
Yes, my lord.
Learned
My
counsel
lord will kindly record my statement, my lord. This is on
Learned
instructions of
counsel
my
for the petitioner states that the present petitions have become infructuous since the matter stands settled between the parties. He wishes to withdraw the present writ petition. The same is dismissed as withdrawn.
Grateful.
13 to 17.
13 to 17, my lord.
Grateful, my lord.
At least something off the board.
Yes, my lord. Lot of them.
Great.
Lot of them. হ্যাঁ, এটা করবো তো। এটা তো করবো, এটা তো ভালো মার্ক। My lord, I appear for the respondent. This was also kept today, my lord.
Lordship, I am for the petitioner. Your Lordship,
Yes, madam.
that counsel appearing in this matter, Your Lordship is not present today due to personal difficulty. Your Lordship, I need
Last time
some-
also you said the same thing.
Your Lordship, last time
You were
we
there?
did not appear only.
Yes, that is why lordship kept it as a last chance today.
Appear only, Your Lordship. But kindly grant us some more time.
Or next week?
Monday, my lord keeps it then.
Not today.
Man, I think, my lord, she is appearing in all three, 18, 19 and
Yes, Your
20.
Lordship, for all.
18, 19, 20?
Yes, Your Lordship.
Kindly keeps it on Monday, my lord.
Monday, 18, 19, 20.
এইটা নামগুলো দিয়ে দাও।
Huh? Not today.
Respondent is same নাম।
This is not today.
ঠিক আছে? আচ্ছা, এইটা 21 টা?
Much obliged, Your Lordship.
Express, এটাও
এখন রাজি হয়ে যাবে।
21 আপনি আছেন?
না 20 অবধি হয়ে গেল।
21 express.
18, 19, 20.
21, I appear for the petitioner.
I appear for the respondent, my lord.
This is by application section 34.
Lord, to cut short the matter, my lord, it was an unilateral appointment. So if you agrees, my lord, we can set aside the award and, my lord, go for an arbitrator, my lord, by consent of parties. I have no issues. To cut short the entire
Secondly,
34.
there is a second award rectifying the earlier award. Therefore, the leave was granted to file a supplementary affidavit may be placed in the record itself.
Yes,
The
that
last
can
order.
যে কোনো retired judge.
হ্যাঁ, ঠিক আছে।
But my learned friend is agreeable. By consent, lordship appoints any retired judge by setting aside the award. A simple point of unilateral appointment.
Lordship,
Record the consent of both the parties.
Yes,
Lordship, may I suggest one thing? But I have to take instruction without
Monday, lordship keeps it.
Monday,
It
Lordship.
can be
Kindly
finished
keep it.
off, my
The
lord.
same order will be passed on Monday.
Yes,
Just take an
supplementary affidavit filed by the petitioner is taken on record.
ঠিক আছে।
Let this matter be listed on Monday.
দেওয়া আছে, আচ্ছা।
Monday will have it.
Yes, my lord. Great.
Yes, Monday. না, আমরা করছি দিল্লি।
Who's there in 22 to Mr. Sen is there, no?
তাই জন্য কেন করবে? এদিকে চলে
Yes. 22, 23, 24, and 25, right?
yes.
Supply of
Yes, jute. Well, I'll address the question directly on it, Mulad. Kindly see, Mulad, the issue is of breach and damages.
Yes, Mr. Sen will confine it only to the award.
Yes, and only to award and the finding.
And the finding.
And the finding. And that also, Mulad, I'll say, not all the issues.
Not all the issues, the issues which are
which I can really argue.
So let's not argue as a 34 petition. Let's
No, not as an
like a arbitral tribunal petition.
Yes. But if your lordship, as I have told your lordship, the main
Who's on the other side? You're there on the other side? All right. Yes.
Your lordship takes the award, the issues which have been framed by the arbitrator. Award is at page 160.
वो देना दूसरा copy दो. Award is 162.
106.
Yes.
Identical পুরোটাই just 106 ছবি আমরা দেখা
Thank you.
Kindly take 168, the issues which have been enumerated there.
Yes.
But issue number 1, 2, I will really not be pressing, my lord.
Issue number 1, 2, you're not
1, 2,
not pressing.
no. Primary issue, my lord, which will fall for your lordship consideration is 4 and 5.
4, 5.
Now, so my lord, the facts are simply put, their case is that there was a contract.
Yes.
The simple case is of a case of non-delivery by a buyer. That is what they have made out. I have taken several defense before the arbitrator. As your lordship will find from issue number 1 and 2, I tried to say that the contract is not a concluded contract. I had already come out of my obligations at a stage, so there is no question of breach on my part. You cannot terminate post. I have surrendered my obligation under the contract. These were issues raised. Arbitrator finds on the facts that I was obliged to take delivery. I did not take delivery for whatever reason. Now the question is, if there is a breach, what is the principle for the non-defaulting party to be entitled to damages? Is it absolute or is it qualified? According to my respectful submission, it is qualified by 2 conditions. Number 1,
Yes.
if he proves breach, he is entitled to damages not as a matter of course.
Yes.
He must show that he has actually suffered loss by reason of the breach. Number 1. Second, he has a duty to mitigate the loss.
Yes.
If he could have done something which a reasonable person could have done, ought to have done at that stage, which would have resulted in minimization of his loss,
Yes.
and if he has failed to take that steps,
Yes.
then that to that extent, the law will not provide him the. It is not like making a profit out of my breach. It is naturally which arose in the course of the contract. So, my lord, if your lordship sees the Contract Act once, my lord, 73.
Yes, 73.
Compensation of loss or damage caused by breach of contract. Where a contract has been broken. So that is the first part.
Yes.
Prove breach. The party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby. So compensation is what he is claiming. He can claim it only on account of loss or damage which is caused to him. And what kind of loss or damage, that is also qualified, which naturally arose in the usual course of things from such breach. That is number one. Or which the parties knew when they made the contract to be likely to be result from the breach of it. So these are the three issues which he has to prove to be entitled to claim that compensation. Such compensation is not to be given for any remote and indirect loss or damage sustained by the reason of the breach. Now, my lord, if I come to one illustration, which actually explains 73. A contracts to sell and deliver 50 mons of saltpeter to B at a certain price to be paid on delivery. A breaks his promise. B is entitled to receive from A by way of compensation the sum, if any, by which the contract price falls short of the price for which B might have obtained 50 mons of like quality at the time. Kindly note this. At the time when the salt ought to have been delivered. So the compensation has to be assessed on the date of breach. You cannot wait for a future period for the result to be in your favor. That will amount to a profit, making a profit out of my breach. That is not what is contemplated by 73. So, my lord, this is the basic principle which I will be urging, my lord. Kindly now let us come to the award finding on this aspect. Issue 4 and issue 5. Let us come to issue 5. Page 174.
Yes.
In the instant case, contract was concluded by the parties. Purchaser was legally bound to purchase the agreed quantity of jute at the agreed price. Unfortunately, either due to sudden fall in prices of jute or due to financial difficulty, jute mills tried to wriggle out of the contract. It is not in doubt that JCI had to procure the jute, carry the same at their own cost to their respective godowns. Jute has to be stored properly, and as such, they have to undergo a lot of expense. JCI is a public authority, it is public money which is at stake. All the contracts signed by the jute mills and JCI all provide that carrying costs and storage charges have to be paid by the purchaser, and this price is included in the contract price of jute. Moreover, after the contract is signed and the purchaser does not take the jute, the godown remains full, as such paid space remains occupied. Moreover, the costs incurred by JCI to bring the jute to the godown is lost. In this view of the matter, all contracts clearly laid down quite justifiably that defaulting purchaser has to pay storage/garage charges at the rate of 25 per quintal per month, as otherwise the JCI would suffer loss. The fact that as the jute mills violated the concluded contract which they legally had to perform, it caused loss to JCI, and it has therefore the duty to make good the loss. JCI has claimed they have suffered loss as due to recession. Price of jute has decreased from September 2006.
September is the contract date.
September is the contract date. Yes. They have claimed that price of jute was 1340 per quintal in September 2006. which has decreased to 1140 in January 2008. Now, the principal question of date of breach has to be considered. In support of their statement, they have tendered a large number of documents of Jute Bailers Association, which indicated the price of different
Large number, like there's only one document.
of jute on different dates. It clearly appears from the price list of Jute Bailers Association that price of TD5, that's a variety, was 1340 per quintal from another price list published by Jute Bailers Association in January 2008. Date of filing of statement of claim. Kindly note, this is the reference date. It appears that price of the same jute became 1140 per quintal. In view of this difference, JCI claimed that jute mill should make good the loss at the rate of 200 per quintal on the total amount of jute not lifted, since in contract FS5 1352 quintals of jute remain to be lifted. JCI claimed such and such. So far as the other contract is concerned, entire quantity of jute was not claimed. So there were two contracts. In addition, JCI claimed carrier charges amounting to 25 per quintal for 14 months. That is from November 2006 to January 2008. So everywhere, reference date is the filing of the statement of claim which is being taken. And also further claimed an interest at the rate of...
That is statement of claim is September of...
No, that's a contract date.
That's the contract date, September 2006.
Contract.
2006 is the contract date. And breach, if they have to consider, that is on my November letter of 2006, when I'm saying that I'm not going to take any further delivery. That is, just kindly note the page, that is page 60, I think. That was what I placed yesterday. Yes.
That's at page 60.
Page 60.
Which, if any, that is
on this date.
On this date.
November 22, 2006. We have said balance quantity may be treated as cancelled. I'm not going to take delivery. So if this is the fault, if this is the breach, this is the date which has to be taken. So this is the first point which I take. There is no assessment of the tribunal as on the date of breach. This is number one. Then let me go forward. In reply to the aforesaid submission, such and such will very categorically place decision to drive home the point. Yes, this is the point. The loss incurred has to be computed on the date of the breach. JCI could not wait indefinitely and allow the price of jute to fall and suddenly take steps after a long time. Jute mills clearly by their letter dated 22nd November indicated that they could not honor the contract.
This was the letter we have shown.
That is page 60.
Page 60.
And as such, that date has to be taken as the date of breach. Mr. Such and such submitted it was the duty of JCI to try to take steps to minimize the loss. But JCI did not take any steps and neither gave any evidence as to how they tried to mitigate the loss. He submitted that on 22nd November 2006, had the contract been cancelled and terminated, no question of loss would have arisen. In view of this, he submitted a claim should be reserved. Submitted by him, flat amount of 200 per quintal was calculated for ascertaining the loss, when in fact different varieties of jute or different prices were involved in the contract. And as such, the claim should be rejected on the ground of non-applicable. Considering it, this is not the contract. Kindly see, these are the different varieties which had the different rates. So we took the point why 200 as a whole has been taken.
Why 1340, why 1140? Why
From the contract, it appears that even if the date of breach be taken as 22nd November 2006, there has been admitted loss. This is its finding. There has been admitted loss suffered by JCI as the contract price of TD5 was 1500. Though this submission is made by JCI, it has been opposed by the jute mills on the ground that this claim has not been made in the statement of claim, nor it appears from the prayers, has been no same cannot be considered. So this is also the basic proposition that today you cannot make out a third case for the parties. I have come up with a case. If I am making out a case of damages not on the date of breach, but on the date of the filing of the proceedings, arbitrator is with me on the point that yes, it is not on the date of breach.
Yes.
But then whether he could have allowed evidence to come in at all, I will come to the question whether evidence has been gone into or not. What was the situation as on the date of breach? This is the second issue, my lord, which I will argue. Then he accepts the proposition. My lord, kindly see the next paragraph. There is no dispute to the settled position of law that in normal cases, any dispute between private parties, loss has to be assessed on the date of breach or soon thereafter. However, now I will kindly see the reason. However, this is a case between a statutory authority whose entire action must be reasonable. JCI on the date of breach could not be in a position to sell the jute in the open market. But where has he got this?
No evidence, like nothing.
They had to take steps either by public advertising or other established procedure to try to sell, which naturally will require time. So even if this goes on surmise that because of public authority you have taken time till 2008. Where is that evidence at all? That in 2008 you have initiated the public auction system. That is not there. You have just come up with a list of price of 2008. You have not shown that why in 2006 you could not sell to mitigate your loss. And you have only produced the price list of 2008. This, kindly see this line, they had to take steps either by public advertisement or other established procedure. Was any evidence adduced that yes, this was the procedure we initiated lately in 2008? That was not there. That evidence is not there. Moreover, JCI has also the duty to take steps to eliminate the loss, as it is not only the settled position of law, but it is their duty as public authorities to try to eliminate the loss. It could be that, kindly note, it could be that price of the jute which had fallen would rise again. So this is entirely conjecture. And as such, it was prudent to wait and see for this is, my lord, what is contrary to 73. You cannot wait for a time when you expect the price will rise again. Moreover, since the jute mills had no right to cancel the contract, they could suddenly claim to purchase the jute had the price risen. It was, however, not permissible for JCI to wait indefinitely and suddenly come up and claim the loss. In view of the above, I hold that about 4 months' time should be held to be reasonable to enable the jute, JCI to sell the jute. But I can't understand how 4 months is getting, because if November 2006 he is taking the price list of 2008, it's not a matter of 4 months then. JCI has not yet sold the jute, which is still lying in their godown. So then why should you take the price list of 2008 also? So there has been no attempt to mitigate the loss. Since the loss has occurred due to laches and negligence and impropriety of the jute mills, they have to replenish the loss at least to some extent. So far as the quantity of loss is concerned, normal procedure is that loss has to be calculated being the difference of contract price and price of goods in the market on the crucial date. But this is the flaw, not the crucial. The crucial date is the date of breach. Difference between contract price and market price as on the date of breach. That is what 73 says. Unfortunately, contract price of different variety of jute was 1390 to 1500, but the claimant claimed only difference of price of TD5, though different types of jute are involved. Himself he notes However, since the object of arbitration is to dispense justice, tribunal has the power to mold the relief. This is again, my lord, a flaw. I assess the loss on the basis of difference of price of jute in November 2006 and 4 months thereafter. From the price list of the Jute Balers Association, following figures emerge. Kindly see the bracketed portion. No document tendered showing price of TD7. But since from the contract it appears that price of TD7 is less by 70 from the price of TD6, price has been fixed accordingly.
Completely based on.
This is again Dehor's evidence. It appears from the chart that difference of price in 4 months' time is about 165 per quintal. And as such, according to my estimate, interest of JCB is served JCI at the rate of 165 per quintal, not lifted. In view of our findings, so where contract FS5 is concerned, so this is similar, he computes it in this way. Then he goes on to, my lord, the storage carrying charges at the rate of 25 per quintal.
It's an award of a different arbitration.
Then, my lord, reference has been taken to another award passed by another arbitrator that JCI is entitled to claim the same.
A different matter.
The award was tendered in evidence, Rachel.
No.
It's written here, well, the award was tendered in evidence, but I've not found from the narration of the evidence. Rachel.
The records are there.
Records are not there.
My lord, I find from the narration furnished documentary evidence which they wanted to rely upon.
Where is the record?
In fact, my lord, in 2022, my lord, they had filed an application with respect to these records, seeking a direction upon the learned arbitrator to produce the records. Now, that application was filed. Perhaps an order was also passed. That order was.
So what happened to the order?
So the order was passed. Then, my lord, my instructions are that they could not find the learned arbitrator.
They could not find.
Could not find the learned arbitrator. Could not find the records of the arbitral proceedings.
2014 matter.
2010 award.
2010 award.
In 2022, they filed an application, got an order.
But the
So none of you have the
documents were tendered.
I only find here what the arbitrator has written. He is saying furnished documentary evidence which they wanted to rely upon. That is neither here nor there.
Page 167.
Kindly come to 167, last paragraph. That is the only narration by the arbitrator. But the fundamental flaws which I am pointing out, my lord, to your lordship on this award is number one. He could not have taken.
But it's a lawyer. You're not aware of this gentleman?
He's a lawyer.
He's a lawyer.
Punjib Mishra.
He must be here.
No, we'll have to find out.
We shall have to. I shall have to. We shall have to.
Old records से देखे आज वो.
We shall have to find out, my lord.
We can see the old.
But I shall continue on the next day. But in the meantime, I shall find out.
Yes, in the meantime, please try to find out. And
my submissions are narrow to this extent, my lord. Only on the aspect whether the principle of section 73 was adhered to. If not, it is a fundamental error.
But see the records.
Yes, yes, I shall.
Kindly keep it in the
Lord, Lord, I have the order, Lord, the online copy, Lord. May I hand it over, Lord?
Yes, sure. This is past date?
2022, June 2022.
Whose application was it? Your
They
application?
had filed. Lord, they had filed an application.
We have to check.
Please check it if there's an order which has been passed.
If we find the details of the arbitrator, we'll write to him in terms of this order again.
Yes.
তাহলে আমাদের একটা সপ্তাহ সময়
Third, learned senior counsel, Shakur Sen.
তো matter না তো সময় নেই।
Let the matter be listed for further hearing on. When do you want, Monday won't be.
Monday, my lord, your lordship has kept the other
Quite a
matter
few,
also.
ये
Wednesday, if it is.
ये थोड़ा ऑर्गेनाइज करके रखो वरना नाइनटीन्थ ठीक 18th
Great.
and just see the arbitral report.
Yes. But the 37 appeals kindly give some precedence to some days, my lord. Because those are also something like new motions. Because my lord, some person has suffered from an order of the arbitrator. They will be pressing for an interim order from the court. It is like an appeal. So any day of the week, my lord, I don't think there are much of the 37 appeals. So,
We'll see. And even the section 9s.
Yes.
I'm going to put all of them together and.
Yes, when there is, although that higher purchase section 9, your lordship will not take time.
I'm going to finish it off.
Yes.
Yes.
Yes, my lord. Item serial number 7 fixed for 2 p.m., my lord.
When did we fix it for 2 p.m.?
Last day, my lord. On 4th.
The Patna.
Yes, my lord.
You're here.
That is fixed for 2 p.m. There is yet another case I am told.
Yes, there's another matter which is going on. So
Maybe
how much time will you take?
it will take some time because
Some time means how much time? Yes,
so
Mr. Kumar Manish, how much time?
It's 45 minutes.
45 minutes.
45 minutes.
I have tried to summarize my submission, written submission with list of dates and judgments we can give. Then in tomorrow or the forenoon it can be.
You are here till tomorrow.
Yeah.
We'll have
Also, my lord, I have fixed
Afternoon. What matter?
afternoon.
Your lordship have fixed what matter, that is
Yes.
non-commercial matter at 2. So in forenoon, if he tomorrow if he can be taken.
So we'll have it tomorrow then. Since it is there, then we'll have it tomorrow. Let me just finish the other matter tomorrow.
Yeah. I am waiting for the petitioner. My friend is the respondent.
Tomorrow we'll have this matter also. Keep it tomorrow. एक साथ ही 2 p.m. कर दो इसका.
My lord may take it as a first matter, my lord. My lord may take it as your first matter.
No, we'll keep it at 2 p.m. only. Same time we'll try to do both the matters tomorrow. 2 बजे ये we'll keep it both the matters tomorrow at 2 p.m.
But if your lordship kindly take the brief of Indian city property. But I want to first give your lordship a little factual background. Petition opposition.
Indian city. Yes.
But if your lordship will please come to page 55 first. 55 of the writ petition. This is not the genesis of the main whole issue.
Before my learned senior starts, Malad, if I may interrupt once, Malad. Malad, a notice has been served upon the learned advocate general to appear in the matter, Malad. But Malad, the matter being a bit old, Malad, we are not getting the papers right now, Malad. We have also been given to understand your lordship may conclude the hearing today. But I'll only request, Malad, if possible, Malad, if the business permits, kindly keeps it on another day so that we can address.
We have been, Mr. Bandopadhyay, we have been hearing this matter, for the last, this is the third hearing.
Yes, Malad, but
I don't have the liberty because these are matters which I have, got from that board. And my board is absolutely a very heavy board. I want to finish it off. I'm not going to give time.
Malad, if Mr. Kaur, Malad, finishes today, Malad, one more day because we don't have the papers today, Malad.
You assist the court. Why you don't have the papers? Matter has been going on for such a long time.
Malad,
It was there in the other.
we have received the notice, Malad, now to appear today.
This matter has been going on the board.
Yes, Malad. There has been some miscommunication by which the learned advocate general could not appear in the meantime. Malad.
Somebody was appearing. You are appearing for the first time. And
So, Malad, state was there.
State has always been there. And
Yes.
I've been made to understand that the advocate general is going to appear.
Yes.
But he has not been appearing.
But there was no, Malad, he was not apprised of the
But
situation.
he
at
has
all.
to. See, this is
Now,
No, not now.
notice has been served even
So the
before file,
advocate
and even in my, the
I can
earlier
only-
determination.
I can
also.
only make a request, Malad. If the business permits, Malad, one more day may be given
I
for
think
us to address. Malad.
I think it will, but then it has to be soon. I'm not going to give you a lot of time.
My lord. Whenever your
I'm
lordship,
going to forget the matter and
No,
not
no,
do it.
whenever your lordship's business permits, Malad, kindly gives us time after
I'll
Mr.
do it
Kaur
tomorrow.
concludes. Tomorrow, Malad.
We'll finish it off.
Right.
There's no point keeping it. All these things are literally pending. You have to understand.
I understand Malad, completely.
My
Malad, I am rather embarrassed to make this request, but I'll have to make this request. Malad.
Because I think Mr. Kar is going to consume the entire day. So you'll be fortunate enough to get time.
My
That was directed against him.
And you prepare, Mr. Bandopadhyay. You prepare if the advocate general is not coming.
No, I'll get prepared, but I needed the papers to get prepared myself also, Malad.
Please come to page 55.
Yes.
This is a letter dated 29th March 2023.
Yes.
It says, so and so, you are requested to submit the all tenants latest rent agreement from the date of commencement within 3 days from the receipt of this letter. Now, there was no response to this letter.
Oh, page 50?
55. P2, annexure P2. Has your lordship got that?
To all the tenants, details and rent agreement from the date of commencement within 3 days from received of this letter.
So this was given on 29th March 2023. Now, when this did not result in getting these papers, a notice under section 181 and 182 of the Kolkata Municipal Corporation Act was served on the SSC. That letter got a response from the writ petitioners, which is at page 56. The letter is not here, but the reply is here. Page 56, your lordships will find this is a letter dated 15th of June 2023. And Lord, kindly see that, Lord, this refers to the notice date under section 181 and 182. This is another notice which is not on record before your lordships of Kolkata Municipal Corporation Act dated 29th May 2023 for requirement of latest copy of rent lease agreements with tenants of premises number such and such, also known as Thapar House, so and so. Please find attached copy of the lease deeds available as per Annexure A attached. And Lord, the Annexure A is next page, page 57. Now, Lord, your lordships will find that in the ground floor, there is Axis Bank, SBI Life Insurance Company, mezzanine floor, and the other lists are there. 9 floors they have given that these are the floors which are occupied by various tenants. Now, Lord, post this, there was a spot inspection. Lord, is the affidavit in opposition before your lordship? Affidavit in opposition.
Affidavit of
Please come to page 22 of the affidavit in opposition.
page?
Page 22. Kindly give him.
Notice.
Yes, Lord, the notice, and there was a spot inspection also. Affidavit. This is a notice. 19th of September 2023. Has your lordship got that?
Yes.
Lord, it says that it is to inform you that as per available information, inspection books, following tenants occupied various portions in the subject premises. Also from the license data, it appears that in addition to the above tenants, following tenants also occupied various portions in the subject premises at different point of time after the last assessment made by KMC on 4th quarter 2004-5. The details of the tenants and occupiers already recorded in the inspection book and the tenants presently occupying certificate of enlistment issued by KMC is stated below. To enable the municipal commissioner to make proper assessment of annual valuation for the purpose of property tax, it is your statutory duty and obligation to provide necessary agreement and information from the date of initial occupancy as regards to the rent, occupation charges, license fee, etc., inclusive of everything in whichever nomenclature like service charge, maintenance, etc., and premium, if any. Then section 181, 182 is quoted. Then Lord, kindly come to the last paragraph. So you are requested to provide necessary agreement and information from the data of initial occupancy, as regard to the rent, occupation charges, license fee, etc., inclusive of everything in whichever nomenclature like service charge, maintenance, etc., within 7 days from the date of service of the notice.
Yes.
Now, Lord, post this, when we did not receive, Lord, the necessary details which were asked for, Lord, a hearing notice was issued on 4th of January 2024. Your lordships will get that. Kindly, Lord, come back to the writ petition.
Yes.
Page 62 to 75. This revaluation was proposed based on, Lord, whatever information that we had got, spot inspection, etc., whatever the information, this was proposed. Now, Lord, this was on the 4th of January 2024. Now, Lord, on 8th of January 2024, there were further reasons supplied that why we are going to revise these valuation. That is at page 58. Kindly, Lord, come back to page 58. The lordships will find it says notice under section 184 at the top, subject. Which section such and such in respect of premises number 25, etc. Now, kindly see the second paragraph, which says the last assessment of the premises was made with effect from fourth quarter 24-25, 2004-5, with annual valuation 47 lakhs, etc. That notice under 182 and 181 was issued to you multiple times, more specifically on 19th May, 10th August, 19th September by KMC, but you have failed to submit the agreements of all the tenants who were in possession at different material point of time as asked for under 182 read with 181 of the Corporation Act, in spite of issuing notices by KMC. However, you have submitted lease rent agreements of some of the tenants. Because of the non-availability of the lease rental agreements for rest of the tenants who were in possession in subject premises at some point of time or are still in possession, Kolkata Municipal Corporation now has proceeded for assessment under 180 subsection 2 of the Kolkata Municipal Corporation Act on the basis of rent and area as per records available with KMC. Then, Lord, kindly see the proposed valuation and the reasons are given. The tenant Orient Bank of Commerce, who are paying 86,000. Previous was the 86,000, now 1,48,000, etc. The details are all not collected and these are incorporated in the notice. Including the area occupied by the tenants, etc.
But look at the reasonings.
But enhancement of rent.
Enhancement of rent, look at the reasoning of enhancement. Or suppose, for example, you take the second one, Max New York Life Insurance. RR square feet is considered so and so after taking into reference of another tenant, HBL Global Private Limited, who was inducted on such and such. The first one itself, from the letter dated so and so, from the RO of the branch manager, Oriental, the previous rent of the tenant has been revealed. What is the rent which has been revealed?
Look, there are several tenants in the property, and they were showing a lesser rent being collected by them from one tenant than the other one who was paying a higher rent. So this is just a reasoning given. This is not the final order. This is just a reasoning given.
But this is the basis of the final order on which you have enhanced the RV.
I'll just come to that. Huh? In the second example, your lordships will see the certificate of enlistment was obtained on 4th July 2008. Now, my lord, kindly come to page 61.
And if we read in detail, then the previous one, which I just read out to you, Max New York Life, it is based on HBL Global. And if you turn the next page, HBL Global, you don't even have the agreement. So how did you come to the finding?
No, but the rent is per square feet 23 rupees. That is ascertained by spot inspection.
Not by spot inspection. There must be some agreement which must have been given to you. Spot inspection, you can't.
No, rent reference, your lordships kindly see is that HBL Global
HBL
rent
Global.
reference is C, that is certificate of enlistment. So, in the corporation, this is the record of the corporation. They have applied for and obtained certificate of enlistment.
That's where you got the.
Yes, and that's how we got this agreement. They have not provided agreement for all the tenants. But if I wish, I could produce in the certificate of enlistment, the rent paid is disclosed.
All right. Yes.
So most of these, my lord, your lordships will find that has been obtained from certificate of enlistment. Now, my lord, if your lordships please come to page 61.
Yes.
First entry, my lord, first quarter 2017-18. UAA. SAF with effect from first quarter 20 on suo basis as per unsigned area statement obtained from owner, area statement of different agreements of different tenants who were inducted in different point of time, area record in the license report and area found on the spot inspection. This I will, when I place the section, your lordships will see that it is based on the area. I'll place the section. And then, Lord, the subsequent enhancements are all, Lord, on the SAF. Now, Lord, as of date, they have not applied for SAF. There is no application for SAF. Now, it says, in this regard, it is pertinent to mention that it was your statutory obligation to file return under Section 182, read with Section 181 of the Kolkata Municipal Corporation Act 1980, in reply to the notices issued by the KMC asking to file the same and also to file the return under Section 182A of the Kolkata Municipal Corporation Act 1980 for assessment under unitary assessment method. But you have not submitted self-assessment form, SAF, till date, and hence violated the norms as laid down under Kolkata Municipal Corporation Act 1980. Hence, KMC has proposed the assessment under unitary assessment method on suo motu basis from first quarter 2017-18. System generated notices under 184 and 185 Kolkata Municipal Corporation Act for the proposed annual valuation under annual rateable value method for the assessment period such and such in respect of premises number so and so are also enclosed for your perusal. It is also to be noted that system generated notices 185 for the proposed annual valuation for the assessment period under unitary assessment method so and so will be issued after fixation of annual valuation under the annual rateable value ARV method. Now, if you have any objection against the above mentioned proposed annual valuation, you may file the same on or before 10th of February 2024 under Section 186 of the Kolkata Municipal Corporation Act, along with grounds of objection with alternative calculations, etc. Failing which, Municipal Commissioner will proceed to consider the said valuation in accordance with law, and bills will be raised accordingly. Now, my lord, pursuant to this notice, an objection was filed. Your lordships may kindly come to page 77. Lord, please turn to page 78. Around the middle, the paragraphs starting with the word regarding the subject ARV proposal. So also stated that ARV regime had been invoked from the commencement of the Kolkata Municipal Corporation Act. However, by virtue of the second proviso to Section 179 2D of the Kolkata Municipal Corporation Act, as existing prior to Kolkata Municipal Corporation Amendment Act 2006 with effect from 1st May 2007, it was contended that the Municipal Commissioner had an unlimited power to make retrospective revisions of the annual valuation by way of a general revaluation. Pertinently, the provisions of Section 180 of the said Act as on the respective dates of effect of the respective proposals forming the subject ARV proposals did not have any retrospective operation. By the Kolkata Municipal Corporation Act, the second proviso was deleted with effect from, this is not with regard to the amendment, I'll take your lordships through the sections. And then, Lord, they talk about the High Court's order, which read down the provision to 3 years.
Yes.
Point is taken that it was the filing of return was not enforced, everything. But Lord, on factual score, there is no reply. There is no denial of the facts with regard to the areas occupied by the tenant, the tenants' rent that the tenants are paying.
No, what they say factually also, you had served a notice dated 29 September 2023 under Section 181 of the KMC Act.
Yes.
Our company has replied to the same by letter dated so and so. However, you have wrongly contended that our company has not filed any response to the notice under 181 of the Act, which is manifestly contrary to the records.
Lord, the reply is at page 56. I just showed it to your lordship. Page 56 of the writ petition. That is the reply they are talking of. Please come to page 56. Your lordships will find what did they say. They said that please find attached copy of the lease deeds available as per annexure A attached, and that annexure A is not at page 57. On that, the subsequent notice was issued, Lord, which prescribes, Lord, the rent that the tenants are paying on the basis of certificate of enlistment. On that, Lord, in this reply, they have not, Lord, controverted any of the factual issues. These are all on the question of KMC's power, amendment, virus, and Lord, 3 years, not beyond 3 years. So, Lord, on factual score, there were no denial in the representation which they had filed. Now, there were some proceedings taken before the hearing officer, but before the proceedings could be concluded, Lord, the present writ petition was affirmed. The writ was affirmed on 19th April 2024. And Lord, the prayers, if your lordships kindly have a look at the prayers.
Yes. Two to 32B and 182
Yes,
declared
232B,
ultra-virus.
180 subsection 2 declared ultra-virus, and then washing off the memo of 8 January 2024, that is page 51 to 61, 58 to 61, and 13 several notices which are, Lord, in 62 to 75. So, Lord, this is what the writ petition, Lord, had asked for, petitioner had asked for, and this is what the relief claim. Now, Lord, the challenge to the virus, insofar as this writ petition is concerned, is restricted to section 232B and 180 subsection 2.
Yes.
Now, Lord, since it is a pure question of law, I request your lordships to take, Lord, these two sections. We first start, if your lordship kindly takes. But first, kindly come to section 179. There is the provision of the Kolkata Municipal Corporation Act.
Yes.
The revision of the rates could take place, Lord, in two different methods. One under section 179. The other is provided, which is an intermediate change in valuation, which is provided under section 180, 181. I'll come to that section first. First, kindly take section 179. 179 says the annual value of any land or building situated in any ward of the corporation which has been determined before and is in force on the date of commencement of this act shall remain in force and shall be deemed to be annual value for the purpose of assessment of property tax on such land or building under this act until a fresh valuation is enforced under this act. So, Lord, the old valuation will continue until the new valuation is enforced. Please come to the proviso, provided that the annual value of any land or building or both, which has been made before but not finally determined on the date of commencement of the Kolkata Municipal Corporation Amendment Act 2006, shall be determined under the provisions of this Act as were in force prior to the commencement of the Kolkata Municipal Corporation Amendment Act 2006 and shall be deemed to be the annual value in force until an annual valuation is enforced after the final publication of the scheme. Then Lord, second proviso, provided further that where assessment of annual value of any land or building or both has not been made on or before the date of commencement of the Kolkata Municipal Corporation Act 2006 shall be determined under the provisions of this Act as were in force prior to the commencement of the Kolkata Municipal Corporation Act 2006 and shall be deemed to be the annual value in force until a fresh annual valuation is enforced after the final publication of the scheme. Now, Lord, this scheme that is spoken of is the scheme, Lord, under the SAF. But what is contemplated here was that the methods of valuation which is applied in terms of the provisions of the Act will continue till the scheme is published. Now, Lord, then, Lord, Section 2D is not in question here, but Lord, I'll come back to 2D. But Lord, let me first address your Lordship on Section 180 first. 180. If your Lordships kindly come to Section 180, this is intermediate revaluation. Notwithstanding anything contained in Section 179, the corporation, subject to the prior approval of the state government, may by resolution direct a general revaluation of the lands, etc. That's not important. Kindly come to 2. The municipal commissioner may cause any revision to be made in the annual valuation of the land or building in the following cases: when the nature of the financial terms of occupancy changes, when the nature of its use changes from residential to commercial, etc., when a new building is erected. 5. When on an application made in writing by the owner, personal liable to pay property tax, it is established that during the period of the annual valuation remaining in force, its value has been reduced by reason of a substantial demolition, etc. Please come to the proviso. Provided that such revision of annual valuation of any land or building, Lord, this was, Lord, inserted in 2022. That such revision of annual valuation of a land or building shall ordinarily be made within 6 years from the date of occurrence of any of the provisions above circumstances, but such period shall not apply where the owner liable to pay property tax fails to submit return under Section 182 or suppresses the occurrence of any such circumstances. So, my Lord, if the return is not filed or if the form is not filed, the corporation is not within, it is not within the knowledge of the corporation that there is a change in the rent that the landlord is receiving, or there's a change in the occupancy. As a result, there is a enhancement of rent. Now, Lord, this provision was included in 2022 along with 179(2)(d). So, Lord, I'll address this both, but insofar as the first petition is concerned, the petitioner has not challenged any of these provisions, the virus of any of these provisions. So, my Lord, one is the periodic valuation, one is an intermediate valuation.
When
Now,
you say the first petition,
not mine, Indian city property. City properties I have challenged.
Right. In the other petition,
he has challenged under the city property. He has challenged 2 sections: 180 subsection 2 and 232.
2B
In
and
the other matter, that is the second.
Sahujan
petition. That's a second.
Sahujan.
This concentration is only on 179 2D. Here there are 2 sections. There is 1 section. Now, Lord, your Lordships have taken, Lord, please take section 181 once, which says submission of return. The municipal commissioner may, with a view to enabling him to determine the annual valuation of any land or building, any ward or part thereof, and the person primarily liable for payment of any property tax on such land or building, by notice require the owner or occupier of such land or building or portion thereof to furnish a return in such form, within such period, and in accordance with such procedure as may be prescribed. The municipal commissioner may, by notice, require the owner or the occupier of any land or building or portion thereof, in any ward, part thereof, used to public cinema, shows, or etc. That's not important. Then every occupier, etc., under subsection 1 shall bound to comply with such notice and to furnish a return within the declaration that the statement made therein is correct to the best of his knowledge and belief. The municipal commissioner or any person subordinate to him and authorized by him in writing in this behalf may, without giving any previous notice to the owner or occupier of any land or building, enter upon and make inspection or survey and take measurement of such land or building and verify the statement made in any return for such land or building submitted under this chapter. So, my lord, 181 and 182 has to be read, my lord, together, because 182 says to enable the municipal commissioner to revise the annual valuation of any land or building governed by any circumstances specified in subsection 2 of section 180, except in respect of a case under clause 5 thereof, the owner or the person liable to pay property tax for such land or building shall furnish to the municipal commissioner not later than 31st day of March of the year immediately following a return in such form as may be prescribed. Then provided that where the owner or the person primarily liable or person liable to pay property tax fails to submit return in the prescribed form, then notwithstanding anything contained in this chapter, the municipal commissioner may revise the annual valuation upon service of notice under section 184, and such revision shall take effect in accordance with subsection 3 of section 180. Now, Lord, a submission was advanced that this is not mandatory because there is no penal consequences provided.
Section 610.
May I assist your lordship? Schedule 6 is, Lord, after section.
I got it. Yeah, schedule 6.
The lordship will find section 181 there.
(181) is there, 183 is there.
181 is there, 183 is there. Lord, 182 is a consequence of 181. Your lordships may kindly have a look at 182 once again.
We can't read it like that, can we?
Let kindly come to 181. Let's read 181. 181 says the municipal commissioner may, with a view to enabling him to determine the annual valuation of land or building in any ward, and the person primarily liable for the payment of any property tax on such land or building, require the owner or occupier of such land or building or portion thereof to furnish a return in such form, within such period, and in accordance with such procedure as may be prescribed. The municipal commissioner may by notice require the owner or occupier of any land or building or portion thereof used to public cinema shows, etc. So, my lord, when the notice is served that you file your return or furnish the details, Lord, that is mandatory. So 182 is consequence of 181. Normally, Lord, if I submit a form, normally it is open to me to submit a form. But if I don't, then 181 power is exercised by the commissioner. And once the commissioner says that you file a form or you file the details, that is mandatory. Lord, kindly consider this. If it is held to be non-mandatory, then Lord, these provisions become ocious. Because a person, if he does not file a return or does not disclose to the municipality the change in the tenancy, the municipal officer can't go and check the premises every day. It is expected that the statute has made this provision because the owners will come forward and submit their return.
That is the reason why you have the power that if somebody fails to disclose somebody, there's a provision where you can go back to.
Exactly. I was just coming to that. That, Lord, that is the reason why that provision is there. Because, Lord, even otherwise, if your lordship finds that if there is a suppression, from the date of knowledge, I can always go and reopen. That is exactly what happens. So, Lord,
but how far you can go back? That is
I'll just, Lord, come to that. Whether it can go back beyond 3 years. That is what is troubling your lordship. I'll straight away address that. But before that, I just want to draw your lordship's attention to 2 other sections. Please come to 182A.
Yes.
Lord, not the new one, Lord, the old one. That must be, Lord, in the book, just below the section. That
Okay.
Lord, is it there, Lord? It says non-compliance of the requirements of 181, 182. Has your Lordship found that? Just below the section.
Yes, just
Whoever fails to comply with a notice or defaults in furnishing a return as required under section 181 or 182 shall not be entitled to file objection to any assessment to which such notice or return relates. Has your Lordship got that? The unamended provision, Lord, of section 182A. This was amended, Lord, in 1996.
This is not provided that non-filing of return of self-assessment, right? That's the one. Yes. Maybe increase Yes, what are you reading in here?
Lord, your Lordship sees that this section itself said
Yes.
that it was mandatory because then it took away the right to file objection. And then, Lord, it was amended in 2006. That amendment is
2006, no, sir, 96.
Oh.
We amended 10 years ago, 96. So it is no longer mandatory.
এটা কি 96
96.
Wait. No. The old section. Kindly give me 1 minute, Lord.
96.
Old section got amended in 1996. No. Lord, I believe, Lord, this came into force with effect from 15th May 1984, as your Lordship. There is some confusion.
Where do you get that?
96.
96
96.
This was amended in 1996.
96.
4th January 84, the Act came into force. This came into force on 18th May 84. This was deleted in 1996 by the 96 Amendment, 10 years before 2006.
Lord,
Yes.
182A was amended, according to my learned friend, and he is right, in 1996. So, let us say that from 1996, 182A was not there.
Yes.
But Lord, 181 and 182 is there. And 181, Lord, makes it mandatory because I have shown from Schedule 6 that, Lord, this section was made mandatory. Lord, 183 deals with notice of transfer. If your Lordship looks at section 183, Lord, 182A, my learned friend is right. This was amended in 1996. So we are concerned with the period, perhaps, Lord, beyond that.
Yes.
183 deals with transfer, but we are not really concerned. So, my Lord, the first submission which I wanted to make was section 181 and 182. If they have to be read together. And the statute makes it mandatory for a person to file the return. If they don't file the return, then, Lord, power under 181 is exercised. If the return comes in time, then, Lord, question of exercise of power under 181 does not come. So, my lord, this is now 182A has been, my lord, introduced with effect from 2006.
Yes.
And, my lord, it says after commencement of Kolkata Municipal Corporation Amendment Act 2006, as required by the corporation, any owner of land comprising the building and vacant land or any vacant land or covered space of building or any other person liable to pay the property tax or any occupier, in the absence of such owner or person, shall file a return of self-assessment within such time as corporation may by order determine. So, my lord, this is now the provision for filing return for self-assessment, and this is, my lord, this has come into effect with the Amendment Act 2006. Now, my lord, please come to the proviso. The proviso, my lord, which is says, provided that in case of non-filing of return of self-assessment, has your lordship found that, notwithstanding anything contained in so and so till the fresh valuation is made after final publication of the scheme, existing tax as mentioned in the subsection may be increased every year on and from the date of final publication of the scheme by such percentage not exceeding 5%, as may be decided by the corporation, and such owner or occupier or person liable to pay the property tax, as the case may be, shall continue to pay the same, which will be subject to adjustment after fresh valuation under the scheme. So, my lord, there is a provision for automatic increase post 2006 if the self-assessment return is not filed, or for self-assessment form is not filed. Then, my lord, please come to the second provision, the proviso. Provided further that if any change in the nature of occupancy or nature of use or any additional alteration of any other circumstances of revision as specified under subsection 2 of section 180 occurs prior to final publication of the scheme, then corporation may amend the assessment and consequential tax as mentioned in the foregoing proviso. Now, Lord, I just pause here for a moment. Under 180 subsection 2, before the scheme is published, Lord, the corporation retained the power to revise the valuation till the self-assessment form is filed and the self-assessment is made from a particular quarter. That is, Lord, contained in section 182A, which is brought, Lord, in 2006. So, Lord, what has happened? Here, Lord, the self-assessment, if your lordships kindly, Lord, goes back to that document which I was showing, dated 8th of January, sorry, page 58. At 61. Lord, the valuation with effect from 2005 and 6, because, Lord, as on the date the section came into effect, they did not apply, and Lord, the valuations therefore was taken to be the revalued, and at page 61 your lordships will find that on suo motu basis this self-assessment was proposed. This is, Lord, in line with section 182A. Now, Lord, two things. If your lordships now takes to the sections 232A and 232B.
Yes.
Certain provisions applicable prior to enactment of the Kolkata Municipal Corporation Amendment Act 2006 shall continue to be in force. Notwithstanding anything contained in this act, the provisions of section 171, so and so, which were in force immediately prior to the commencement of the Kolkata Municipal Corporation Amendment Act 2006 shall continue to be in force until final publication of the scheme under subsection 1 of section 174 of this act, as amended by the Kolkata Municipal Corporation Act 2006, provided that preparatory works under so and so, as amended by the Kolkata Municipal Corporation Act, leading to the final publication of scheme shall continue. Now, my lord, this read with section, Lord, 182A, your lordships will find this is merely, my lord, reiterating what is already contained in section 182A. Lord, what had happened is this, that Lord, when 182A came into force, the point in issue was that what will happen till the scheme is published. This has been taken care in the proviso, but this is also reiterated in a separate section under 232A. This is not, nothing new is introduced. Now, my lord, also take into account 232B.
Yes.
Certain provisions applicable prior to publication of the scheme shall continue to be enforced. Notwithstanding anything contained in this act, the provisions to subsection so and so, so and so, so and so, which were in force immediately prior to commencement of the Kolkata Municipal Corporation Amendment Act 2006, shall continue to be enforceable in respect of any action as to be taken for the purpose of assessment of annual valuation and levying of property tax or any step relating thereto for any period prior to publication or enforcement of the scheme under subsection 1 was section 174, read with clause A of subsection 2 of 179 as amended by the Kolkata Municipal Corporation Act 2006. So, my lord, this is again a declaration that these provisions will continue to operate and enforceable for any period prior to publication of enforcement of scheme under subsection 1 of section 174. So basically, my lord, these two sections, in my humble submissions, were incorporated so that there is no void between the regular tax that was being imposed or revision that was taking place and, my lord, introduction of the new self-assessment scheme. This is basically saying that till the self-assessment scheme takes over, the old act will continue. The old procedure will continue. But there is a procedure, there was a prescribed procedure under the act for assessment of tax. That procedure of assessment tax was being changed by the amendment.
Yes.
The self-assessment procedure. This is absolutely a clarificatory provision which says till the self-assessment takes over, the old provisions will continue. Lord, I will deal with the order of the division bench. But Lord, let me first address your lordships on the provisions of the act. There is a regime of tax, how that tax is to be levied, whether it will be periodical, intermediate, those are the provisions of the statute. Now, a new regime is coming.
Yes.
Changeover might take time. So, my lord, these provisions are clarificatory that till the changeover takes place, the old provisions will continue. These are implicit in the provisions, Lord, that I showed to your lordships, including section 182A.
Okay.
But it is made explicit by incorporation of these two sections, 232A and 232B. Now, my lord, may I just first take your lordships to the judgment of the division bench, and then, Lord, I come back to the provisions. Compilation. 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 একটা compilation. আমার কম্পাইলেশনটা কোথায় গেল? এটা আচ্ছা 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 আচ্ছা
Is it the same compilation or have a different compilation?
Compilation given by my learned friend.
Same.
No. Yes. Yes. Lord, page 30 of this compilation, the judgment starts. Please come to para 13 at page 32. First of all, a look at certain sections of the Kolkata Municipal Corporation Act 1980 is necessary.
Yes.
First, we set out the second proviso to section 179 2D. 179 2D may be revised on the expiration of each such period. Provided further, this proviso, Municipal Commissioner may, on the expiry of such period, revise the annual valuation of such land or building at any time, and such revised valuation shall take effect from the beginning of the quarter from which the annual valuation would have been revised under this clause. So, my lord, the absolute discretion was given to the municipal commissioner without putting any fetter or any time limit within which this can be done. Now, my lord, this is paragraph 13. This was the offending provision which was challenged before the division bench. Then your lordships may kindly come to 17. Mr. Kapoor cited section 573 of the Act. It is in the following terms. 573. Recovery of certain dues of corporation, save as otherwise provided in this Act, or the rules or the regulations made thereunder, any sum due to the corporation on account of any charge, cost, expenses, fee, rate, or rent, or any other account under this Act, or the rules, etc., if it were a consolidated rate, provided that no proceedings for recovery of any such sum under this section shall be commenced after the lapse of 3 years from the date on which such sum becomes due. Now, my lord, would your lordship kindly come to kindly take this book, section 573. Lord, the proviso starts with the word provided that no proceedings for recovery. Has your lordship got that? Section 573.
Yeah.
It says no proceedings for recovery of any such sum under this section shall be commenced after the lapse of 3 years from the date on which such sum becomes due. Lord, please come to chapter 16, section 214.
Yes.
But the heading is recovery of taxes by the corporation. Has your lordship found that?
Yes.
Manner of recovery of taxes under this Act, save as otherwise provided in this Act, any tax levied under this Act may be recovered in the accordance with the following procedure and in such manner as may be prescribed. By presenting a bill, by serving a notice of demand, by distrent and sale of defaulters' movable property, by attachment and sale of defaulters' immovable property, in any case, property tax on lands and buildings by the attachment of the rent due by a certificate under Bengal Public Demand Recovery Act. So, my lord, this prescribes the recovery, how the tax is going to be recovered. And this is post presentation of the bill. Now, my lord, what the division bench felt that you have fixed 3 years for recovery. after presentation of the bill. But here there is no time limit prescribed. Your Lordships will find the discussion now. Kindly come back to the judgment. Paragraph 18. The proviso is very important. It says that no proceedings for recovery of inter alia municipal tax shall be commenced after the lapse of 3 years from the date on which such sum became due. Now, my lord, this is what the troubling factor. Not became due from any of these things which happened. Under the second proviso to subsection 2 of section 179 of the said act, the proviso to section 573 would be rendered odious by giving the commissioner the power to collect unlimited tax by unrestricted revision of the annual valuation of the premises for an unlimited period of time. Theoretically, the tax would become due on the date of revision made by the commissioner, but the real effect is that the persons liable to pay tax for a property could be fastened by the commission with liability to pay tax, otherwise not realizable, long after the period of limitation. Number, the mind of the court was that if you had presented the bill post valuation, you get 3 years time to recover. And here is a case where unlimited power is given. So therefore, I read 3 years to the section. Now, my lord, that happened because there was no time limit prescribed under the section. My learned friends, my lord, on both sides, for both the writ petitioners, they harped, my lord, on the point that the division bench has fixed 3 years in interpreting the expression any time. Lord, that is cleared in paragraph 18 of the judgment. The court says that if your lordship sees it says under the second proviso to subsection 2 of section 179 of the act, the proviso to section 573 would be rendered odious by giving the commissioner the power to collect unlimited tax by unrestricted revision of the annual valuation of the premises for an unlimited period of time. Now, my lord, this second part, it says theoretically the tax became due on the date of the revision made by the commissioner, but the real effect, the persons are liable to pay tax could be fastened by the commissioner with liability to pay tax, otherwise not realizable, long after the period of limitation. Look, there is a Supreme Court judgment which I will cite. Supreme Court says that this is immaterial. Even if there is a revalidation, by reason of revalidation, the liability is extended for number of years, that is immaterial. But Lord, what I want to address your lordship here is that all this issue came up because there was no time limit prescribed in terms of section 179 2D. Now, my lord, subsequently, 179 2D was amended in 2019 and then, Lord, in 2023. This is not, I have made a comparative chart because the first one is there in the judgment. First, the proviso provided that municipal commissioner may, on the expiry of such period, make and revise the annual valuation of such land or building at any time, not beyond 6 years, and such valuation shall take effect from the beginning of the quarter from which the annual valuation would have been revised under this clause. Provided further that when annual valuation of any land or building has not been made and revised on the expiry of any such period, the previous annual valuation shall continue to remain in force until it is so revised. Then 2023, notwithstanding anything contained in this act or any judgment or decree or order to the contrary, the annual valuation of such land or building may be revised at any time not beyond 6 years from the date of expiration of each such period, and such valuation shall take effect from the beginning of the quarter from which the annual valuation could have been revised. Then where it had already been made or revised beyond such period, the same, including the relation of property tax, on the basis thereof shall be deemed to be valid, and any outstanding property tax on such revision shall be recoverable. Now, my lord, I tell your lordship, 2019 amendment was made. This judgment of the division bench is dated 26th of April 2018. Lord, then of course, Lord, the matter traveled to the Supreme Court, etc. Ultimately, it rested, and thereafter this amendment came in 2023 with effect from 9th June 2023. Now, Lord, coming back to the judgment of the division bench, if your lordships kindly come to page 34, paragraph 25. The power conferred on the municipal commissioner to revise the annual valuation of land or building under section 179(2), second proviso, was indeed unlimited in point of time and very wide, it should be wide, in its amplitude. Any piece of legislation where unguided or uncanalized power is given to an authority to that extent invalid, therefore the power conferred on the commissioner, in my opinion, is indeed so unlimited that it falls foul of Article 14 of the Constitution of India. So, my lord, interference of the court was only because of that proviso stopping at any time. Correct. Now, my lord, now question is with regard to the amendment. Lord, before I come to it, I think Mr. Mujumdar had handed over to your lordship the statement and object of the amendment. Yes.
No. Do you have a copy?
Yes, I have a copy. Your lordship, Lord, I think, Lord, last two pages of the bunch, Lord.
Yes.
Lord, lordships kindly consider, it is considered necessary and expedient to amend the Kolkata Municipal Corporation Act inter alia for the purposes of allowing the Municipal Valuation Committee to exercise option for categorization of the blocks, etc., giving overriding power for making periodic assessment of any land or building within stipulated period after expiration of earlier period of assessment and giving effect of such period of assessment retrospectively, then fixing period of ordinary revision of assessment of any land or building as well as non-application of the said period on failure of submission of return, providing clarification, lordships may kindly mark this, providing clarification for giving effect of any intermediate revision in assessment keeping consonance with the relevant provisions of the Act. Then empowering the corporation to increase existing rate of tax, empowering municipal commissioner to cause suo motu mutation, providing clarification of adding explanation to section 185. Lord, your lordships will kindly now come to the bill. The sections which are Lord considered 174, 179, 180, 182, 182A, 183, 185, 186, 187, 199, 203, then Lord 232A, that is at page 4, 232B, 232A. Sorry. 232B টা আছে নেই। So, my lord, basically the purpose of the amendment is very clear. It says that allowing overriding, giving overriding power of making periodic assessment, and also providing clarification for giving effect of any intermediate revision in assessment, keeping consonance with the relevant provisions of the Act. Now, my lord, at least in statement and object, reading the statement and object, or the provisions of the bill, and which is ultimately amended, your lordship would not find there is any attempt to nullify a judgment of a court. The legislative power goes far beyond the provisions of only identifying a judgment and nullifying that judgment. That is not the intention of the legislature. The legislative intent was to provide the deficiency in the section which was considered by the division bench by fixing a period of 6 years. It is not if a legislature, my lord, fixes a period of 6 years, it does not mean the legislature is attempting to override the judgment. The judgment's interpretation was based on the then existing statute, which says any time and stops at that. Now, my lord, legislature, my lord, rectifies that, curing, my lord, a defect in the provision. And in the process of cure, the legislature says that 6 years. Now, my lord, revalidation, I'll address your lordship separately, but my lord, this is a pure curative action of the legislature. And it will appear from your lordships, it will appear from the judgment of the division bench. The division bench was only concerned about the fact that an unguided power is given to the commissioner without any limitation.
Right.
The issue is whether, my lord, the statute can put that limitation post delivery of that judgment. Because power to legislate always remains. And that is how the Supreme Court in repeated judgments, Lord, have held that if an amendment is only says that judgment and orders will not be binding and the officers can go on collecting the tax, that is a direct, Lord, affront to the court. But when the defect in the statute or the deficiency in the statute is made up or cured, Lord, it can't be said that legislature for all times to come have to stick to that 3-year period as interpreted by the division bench. This is, Lord, the crux of the matter.
3 years, then further extended to 6 years.
3 years is extended to 6 years, and there is a revalidation that whatever tax has been assessed, that will remain. I'll address your lordship separately on that. But Lord, as of now, the provisions which my learned friends are challenging, 2 sections, 180 subsection 2 and 232B. Lord, these are absolutely, Lord, a curative action, curing, Lord, any defect, because if your lordship looks at section 180 subsection 2 once. The proviso. The proviso says, provided that such revision of annual valuation of any land or building shall ordinarily be made within 6 years from the date of occurrence of any of the above circumstances, but such period shall not apply where the owner or the person liable to pay property tax fails to submit return under section 182 or suppression or occurrence of any such circumstances. Now, my lord, what happens if I come to know beyond 6 years, I lose my right to seek revision. This is what is protected by the statute. Lord, 180 subsection 2 was not under consideration by the division bench. Division bench was only considering 179(2) D. This amendment came not in 2000 by 2022 Amendment Act, 9 June 2023 on the same day. But Lord, the purpose is the same. Lord, may I just analyze this?
Yes.
Lord, the legislature, though Lord 179(2)D was the consideration by the division bench, legislature, while curing 179(2)D, whatever Lord the rectification or Lord the amendment, had also thought of a situation that what happens when the return is not filed. Will 6 years apply? Normally 6 years will apply in case of all revisions. But where Lord the informations are not given, 181 is not complied with, and then it comes to the knowledge at much later. Those cases will not be bound by 6 years. This is what the legislation says. But to my mind, if they had amended 573, if your lordship looks at 573 once again, the analogy of 573 in the division bench judgment, they could have easily not amended 573. This 3 year could have been extended to 12 years. But they didn't do that. Because Lord, they kept in mind that once the demand is raised, you will have to be agile to enforce your claim.
Well, that might not have been done because of the change in the system. UAA and
yes, change in the system and Lord 5% every year. If you don't file your return, you don't come under the UAE, there is an automatic increase of 5%. The simplest way of getting out of it would have been to amend 573 to 12 years. But they didn't do that because that would have given their officers uncanalized power to wait until 12 years expires to recover the dues. The whole process, in my humble submission, is to ensure that municipal tax is collected. The object is one. The object is to collect the municipal tax that is actually due and payable. My learned friend's contention is my tenants are dead and gone. Then some of them are not there. How do I realize? My right to realize will go. Who stopped you to file the return? You could have filed the return. The provisions of section 181, 180, they were always there in the statute. You have taken a calculated risk by not submitting the return because your valuation would have gone up, your tax would have gone up. But Lord, point is that the object gets defeated. The object of the Calcutta Municipal Corporation Act will get defeated if Lord, it is revision is restricted to 3 years. The
under which other provision? Under any other statute where the period has been
Lord, assessment, I think, Lord, I was trying to lay my hand on, say, Delhi Municipal Corporation Act or Lord, Bombay Municipal Corporation Act.
Even Delhi, there's a judgment of Justice Bhatt, 3 years. Same as this.
Lord, realization, post presentation of the bill. 3 years, Lord, is the realization time. If I file a suit seeking, Lord, enforcement of a claim, I have to file it within a period of 3 years. It is akin to, Lord, enforcement of my right of realization.
Even under the Income Tax Act, if
Yes.
assessee is not filing it,
Yes.
how backwards you can go?
Lord, if the return is not filed or some income is suppressed, Lord, from the date of knowledge, it can be reopened. I'll get the sections, but Lord, it can be reopened. Lord, the whole issue is, Lord, intermediate valuations depends on the change of, Lord, the rent. The change of rent.
That's right.
And Lord, this is, Lord, a realization on change in the annual valuation. The tax is assessed. Lord, after all, Lord, this is a state subject. The municipal tax is a state subject. And there is a law which governs realization of this tax. Now, rightly or wrongly, there was a provision where, Lord, no period was prescribed. The court commented on it. But, Lord, it is the legislative, Lord, mandate under the Limitation Act. The government companies, they have 30 years, Lord, limitation for the purpose of filing the claim. Government or section, I'll give you a lordship, there's a West Bengal amendment where, Lord, the government organization have 30 years as limitation. This is legislative wisdom. Lord, the only concern of the court is that whether the legislative act has extended to only nullify the judgment of the court without curing the defect or without amending the provision or bringing in, Lord, sufficient provision. Lord, I'll show to your lordship, there are statutory provisions where beyond 3 years provisions are there. It's 3 years only on the account of realization after the claim is lodged. The statute does not give you more than 3 years to realize. But in a case of fraud or in a case of suppression, you get 3 years from the date of knowledge. But these are all, Lord, for the purpose of realization of a claim. Here we are concerned about the assessment. Now, Lord, before I deal with the judgment cited by my learned friend, I would like to submit, Lord, a compilation, if your lordship's, Lord. Yes. Kindly, Lord, ignore the note for the timing. I'll just draw your lordships to the judgments. Please come to page 14. This is paragraph 4. This is first judgment is 2015, volume 1, SCC, page 1. Please come to paragraph 1 first. Delay condoned, leave granted in all these matters in this batch of appeals, most of which are preferred by the commissioners of income tax, with the exception of few appeals filed by the SSC. The question of law which has fallen for consideration is as to whether the proviso appended to section 113 of the Income Tax Act, hereinafter referred to as the Act, which was inserted in the section by Finance Act, is to operate prospectively or it's clarificatory and curative in nature and therefore has retrospective operation. So, Lord, this was the issue. Please come to paragraph 7. It is clear from the aforesaid narration that the High Court has taken the view that proviso inserted in section 113 of the Act by the Finance Act 2002 was prospective in nature, and the surcharge is leviable under the aforesaid proviso could not be made applicable to the block assessment in the question of an earlier period from 1489 to 10th February 2000 in the instant case. Then reference order. It is so happened that this very issue about the said proviso to section 113, whether it is clarificatory or curative in nature, and therefore can be applied retrospectively, or it is to take effect from the date on 1st June 2002, when it was inserted by the Finance Act, attracted the attention of this court and was considered by the division bench in CIT Suresh N. Gupta. The division bench held that the said proviso is clarificatory in nature. When the instant appeal came up before another division bench, for hearing the said division bench expressed its doubt about the correctness of the view taken in Suresh and Gupta and directed the registry to place the matter before the Honorable Chief Justice of India for constitution of a larger bench. Now this is how, my lord, it comes, lord, to the larger bench. Kindly come to paragraph 15.
Yes.
It would be some significance to point out at this stage that insofar as rates of tax chargeable in case of block assessment is concerned, that is not provided in the Finance Act. Pertinently, the proviso to this section effect has been made in the Income Tax Act itself and is contained in section 113. It says 113 is then quoted, tax in the case of block assessment. The total undisclosed income of the block period determined under section so and so shall be chargeable to tax at the rate of 60%. Then the proviso is also quoted, provided that tax chargeable under this section shall be increased by a surcharge, if any, levied by the Central Act and applicable in the assessment year relevant to the previous year in which the search is initiated under section 132. From the reading of the aforesaid statutory provisions in the abstract, particularly relating to surcharge, it is clear that though provisions for surcharge under Finance Act has been in existence since 1995, insofar as the levy of surcharge for block assessment is concerned, it is introduced by insertion of aforesaid proviso to section 113. It is in this background the question has arisen as to whether this surcharge on the block assessment has been levied for the first time by the aforesaid proviso coming into effect from 1st June 2002, or it is only clarificatory in nature because of the reason that the provisions of surcharge was made in the Finance Act in the year 1995 that covered surcharge in the block assessment as well. Now, Lord, please come to paragraph 28.
Yes.
Of the various rules guiding how a legislation has to be interpreted, one established rule is that unless a contrary intention appears, a legislation is presumed not to be intended to have a retrospective operation. The idea behind the rule is that current law should be governed current activities. Law passed today cannot apply to the events of the past. If we do something today, we do it keeping in view the law of today and in force, and not tomorrow's backward adjustment of it. Our belief in the nature of law is found on the bedrock that every human being is entitled to arrange his affairs by relying on the existing law and should not find that his plans have been retrospectively upset. This principal law is known as lex so and so. The law looks forward, not backward. As was observed in Phillips versus such and such, a retrospective legislation in contrary to the general principle that legislation by which the conduct of mankind is to be regulated, when introduced for the first time to deal with future acts, ought not to change the character of past transactions carried on upon the faith of the then existing law. The obvious basis of the principle against retrospectivity is the principle of fairness, which must be basis of every legal rule as was observed in such and such. Thus, legislation which modified accrued right or which impose obligations or impose new duties or attach new disabilities have to be treated as prospective unless the legislative intent is clear to give the enactment a retrospective effect. Unless the legislation is for the purpose of supplying an obvious omission in a formal legislation or to explain a formal legislation, we need not note the cornucopia of the case law available in the subject, because aforesaid legal position clearly emerges from the various decisions, and this legal position was considered by the counsel for the parties. In any case, we shall refer to few judgments containing this dicta, so and so. Then, Lord, please come to paragraph 30, the second sentence. If a legislation confers a benefit on some person but without inflicting a corresponding detriment on some other person or no on the public general, and where to confer such benefit appears to have been the legislator's object, then presumption would be that such legislation giving it a purposive construction would warrant it to be given retrospective effect. This exactly is the justification to treat procedural provisions as retrospective. Then what the judgments are quoted, kindly come to paragraph 32. Let us sharpen the discussion a little more. We may note that under certain circumstances, a particular amendment can be treated as clarificatory or declaratory in nature. Such statutory provisions are labeled as declaratory statutes. The circumstances under which the provisions can be termed declaratory statutes are explained by Justice G.P. Singh in the following manner. The presumption against retrospective operation is not applicable to declaratory statutes. As stated in case the approved by the Supreme Court, for modern purposes, declaratory act may be defined as an act to remove doubts existing as to the common law or the meaning or effect of any statute. Such acts are usually held to be retrospective. The usual reason for passing a declaratory act is to set aside what Parliament deems to have been a judicial error, whether in the statement of the common law or in the interpretation of statutes. Usually, if not invariably, such an act contains a preamble and also the word declared as well as the word enacted. But the use of the word it is declared is not conclusive that the act is declaratory, for those words may at times be used to introduce new rules, law, an act, and later case will only be amending the law and will not necessarily be retrospective. In determining, therefore, the nature of the act, regard must be had to the substance rather than to the form. If a new act is to explain an earlier act, it would be without object unless construed retrospective. An explanatory act is generally passed to supply an obvious omission or to clear up doubts as to meaning of the previous act. It is well settled that if a statute is curative or merely declaratory of the previous law, retrospective operation is generally intended. The language shall be deemed always to have meant is declaratory and is in the plain terms of retrospective. In the absence of a clear words indicating that the amending act is declaratory, it would not be so construed. An amending act may be purely clarificatory to clear a meaning of a provision, municipal act, which was already implicit. A clarificatory amendment of this nature will have retrospective effect, and therefore, if the principal act was existing law, which the Constitution came into force, the amending act also will be part of the existing law. Then, Lord, paragraph 33. This Mohanlal Bhagwan Das's case, paragraph 8 is quoted. May I just place this paragraph 8? The amending clause does not seek to explain any pre-existing legislation which was ambiguous or defective. The power of the High Court to entertain a petition for existing revision jurisdiction was before the amendment derived from section 115 of the Code of Civil Procedure, and the legislature has been amending act, not attempted to explain the meaning of that provision. An explanatory act is generally passed to supply an obvious omission to clear up doubt as to the meaning of the previous act. Please come to paragraph 37. When we examine the insertion of provision,
Yes.
When we examine the insertion of the proviso in section 113 of the Act, keeping in view the aforesaid principles, our irresistible conclusion is that the intention of the legislature was to make it prospective in nature. This proviso cannot be treated as declaratory, statutory, or curative in nature. So, here, section 113 was being interpreted. Then ultimately, paragraph 42, your lordships will find that, Lord, 42 and the rest, Lord, it was held to be a retrospective operation. Lord, the object of citing this judgment was twofold. First is, Lord, in interpreting an amendment, one has to see whether, Lord, it introduces a new provision, creating a new right, or, Lord, taking away a new right. If it does, then, Lord, it's prospective. But if it's merely clarificatory, or, Lord, it's supplying an error, supplying remedy to an error, or my lord, it's really corrective in nature, in the sense that some deficiencies in the earlier provision which is being removed, then my lord, it is has a retrospective effect. Because my lord, a lot of argument was advanced that this couldn't be made retrospective. So my submission is that if the statute itself is rectifying its defect or error which was pointed out, then Lord, it has a retrospective effect. Now the question is whether
nowhere in the object or scope it is mentioned like that. Even at the time of the amendment.
Lord, it says clarificatory. It's providing clarification for giving effect of any intermediate revision in assessment, keeping consonance with the relevant provisions of the Act. This is clarificatory, it says. That is the reason, my lord, I showed your lordship the statement of objects and reasons. Roman 4, your lordships will find it says that providing clarification for giving effect of any intermediate revision in assessment, keeping consonance with the relevant provisions of the Act. So it is sufficient indication that it is in continuance of the provisions of the Act. It is giving a clarification. Okay. Sorry, my lord, I missed Ms. Sengupta's pointing out. Yes, yes, it is given, my lord. It's also the validation word is also there. Yes, it says for validation of such periodic assessment which has already been made or revised after stipulated period, including realization of property tax on it. So both, my lord, clarificatory and also, my lord, for protecting the tax which would have otherwise, Lord, become refundable. The validation, Lord, comes post curing the defect. It's basically, Lord, not to lose the tax which has been collected, or which is collectible. This is the validation part. Yes, it also says continuation of certain provisions which were in force prior to publication of the scheme of unit area assessment for the purpose of assessment, or any steps thereto relating to any period prior to the said publication. So basically, my lord, clarificatory, declaratory, and also, my lord, it's maintaining the continuity. Note of the Lord, the next judgment, kindly come to page 45. It's 2018, volume 17, SCC 394. Paragraph. Lord, come to paragraph 3, which is at page 53. Lord, 3 to 5, Lord, explains the facts. Respondent number 2 was classified as non-performing asset, NPA, on such and such under section 13(2). Then, Lord, 4. As matters stood thus, an application was filed by respondent 2 corporate debtor under section 10 to initiate the corporate information resolution process against itself. While the said proceedings were pending, an interim application was filed by the respondent number 1 as personal guarantor to the corporate debtor, in which respondent number 1 took up a plea that section 14 of the code would apply to the personal guarantor, as well, as a result of which proceedings against the personal guarantor and his property would have to be stayed. The National Company Law Tribunal, by its order dated such and such, held that since under section 31 of the code, a resolution plan made thereunder would bind the personal guarantor as well, and since after the creditor is proceeded against, the guarantor stands in the shoes of the creditor, section 14 would apply in favor of the personal guarantor, etc. Then 5. An appeal filed to the National Company Law Appellate Tribunal resulted in the appeal being dismissed by the impugned judgment dated such and such. Appellate Tribunal relied upon section 62 and 3 of the code as well as 31 of the code to find that the moratorium imposed under 14 would apply also to the personal guarantee. So, Lord, this is the issue which comes to the Supreme Court. If your lordships kindly come to paragraph 30. Page. Page 68. Lord, original 14, your lordships will come from paragraph 13, section 14 is quoted. Then, Lord, 31, the Insolvency Law Committee appointed by the Ministry of Corporate Affairs by its report dated such and such made certain key recommendations, one of which was to clear the confusion regarding treatment of assets of guarantors of the corporate data vis-a-vis the moratorium on the assets of corporate data. It has been recommended to clarify by way of an explanation that all assets of such guarantors to the corporate data shall be outside the scope of moratorium imposed. Then, Lord, please come to 33.1 of paragraph 33, page 70. The report of the committee makes it clear that the object of the amendment was to clarify and set at rest what the committee thought was an overboard interpretation of section 14. That such clarificatory amendment is retrospective in nature would be clear from the following judgments. Then, Lord, the judgments are quoted. Shelley Products. Your lordships kindly come to just above placitum E, the sentence starting with the word where the proviso. Has your lordship got that?
Yes.
Consists of two parts. One part may be declaratory, but the other part may not be so. Therefore, merely because one part of the proviso has been held to be declaratory, it does not follow that the second part of the proviso is also declaratory. However, the view that we have taken supports the stand of the revenue that proviso B of section 240 is also declaratory. We have held that even when unamended section 240 Act, the SSC was only entitled, etc. Then kindly come to the last four lines, just placitum G. It is well settled. Has your lordship got that? That the legislature may pass a declaratory act to set aside what the legislature deems to have been a judicial error in the interpretation of statute. It only seeks to clear meaning of the provisions of the principal act and make explicit that which was already implicit. Lord, this is what I wanted to point out. That, Lord, what is done here is, Lord, that it was there, but that the period was there. But, Lord, the period was not specifically there in 179 2D. So, Lord, a period is provided. Kindly, Lord, see the next paragraph.
Yes.
The GP Singh's, Lord, that declaratory statute, that is, Lord, already I placed the other judgment. This is rather copied from there. The mere fact that it is declared, these words are there, that itself is not conclusive. What is conclusive is that, Lord, the totality of the situation assessed. Now, Lord, this is what I wanted to place, and the next judgment is 2020 volume 2 SCC, volume 20 SCC. That's the next page.
Yes. VVF limit.
Yes. Paragraph. Lord, kindly come to paragraph 3.
Paragraph
3. Three is, Lord, at page 87. Lord, this related to an incentive scheme. Lord, if your lordships, Lord, please come to the last line, 3 lines from the bottom.
That incentive refund.
Yes. Was available for the period of 5 years from the date of commencement of commercial production the object of the incentive scheme. What had happened, they had announced certain incentive scheme, which later was amended and withdrawn. So that is the subject matter. Your Lordships may kindly come to paragraph 5. No, we page টা হবে না because this is a continuity. Internal page. This is paragraph 3. Please come to paragraph 5. The original rate petition set up new industrial units in Kutch district. They made an investment in the plant and machinery for more than 20 crores. According to them, almost the entire duty was required to be paid in cash, the whole of which was refundable without any upper cap. It appears that the government of Gujarat announced the incentive scheme 2001 for the economic development of Kutch district. Then various amendments were made to the original incentive scheme notification between September 2001 to September 2004 inter to clarify certain matters and also to extend cutoff date for setting up new industrial units such and such. Then Lord, paragraph 10, if your Lordships kindly come to page 89. The said incentive scheme was amended by another notification which according to the writ petition was relating to a virtual withdrawal of the incentive scheme. The amended notification provided that the benefit of refund would be granted with reference to the value addition which was notionally fixed at so and so. Notification number such and such was also provided for determination of special rate by commissioner in a situation where the actual value
But the reasoning
addition
is
was
different, Mr. Karan. This
not only thing is that here the Supreme Court says that it is the legislative prerogative. Basically, if something is given, that can be taken also. This is how this judgment was. Paragraph 20. If your Lordships kindly come to paragraph 20. It starts at page 103. Please turn the page. Kindly come to placitum B. Therefore,
yes.
Therefore, that the question which are posed by the consideration of this court are whether in the facts and circumstances of the case the subsequent notification which has been quashed by set aside by the High Court so and so can be said to be clarificatory in nature, and can it be said that it takes away the vested right conferred pursuant to the earlier notification of 2001, and whether the same can be made applicable retrospectively, and whether the same has been issued in public interest, and whether the same is hit by the doctrine of promissory estoppel. Then Lord, the answer is given at page 108. These cases are there. 23, Lord, kindly take 23. This 23.4, just above placitum G. It is
Yes.
well settled. Has your Lordship got that?
Yes.
If a statute is curative or merely declaratory, or the previous law retrospective of operation in general intended, an amending act may be purely declaratory or clear meaning of the provisions of the principal act which was already implicit. A clarificatory amendment of this nature will have retrospective effect. Lord 24, Lord, the Supreme Court holds that the notification was retrospective. Lord, I have concentrated on Lord the prospective and retrospective these judgments because Lord, I will rely on the judgment cited by Mr. Banerjee and Mr. Mojumdar for the other point. Lord, I have just tried to restrict myself on the question of retrospectivity or prospective situation because Lord, whether the amendment will be prospective or retrospective, that is also Lord an issue which will tilt the balance so far as the Kolkata Municipal Corporation is concerned. Because if they are unable to Lord recover the taxes, Lord, I am for the time being Lord leaving aside that 3-year bar, because I am saying that 3-year bar was imposed at a point of time. The court interpreted Lord section 179 2D read with 573 to say that that 3-year will apply. But now, Lord, the legislature has put in a time limit.
Madam, you appear for the state.
Yes, my lord.
Stay here.
I am staying in my
Sit down. Sit down, sit down.
So, my lord, my contention is that 3-year was at a point of time when there was no provision in the statute. Court never said that this 3-year remains static for all times to come. It can't be amended by the legislature. The legislature, in its own wisdom, obviously, without showing any disrespect to the court, has supplied the defect in the provision of the act, which is within the domain of the legislature. Because, Lord, the division bench could not have legislated, it could only interpret. And in interpreting, it had found a provision.
That's why it has read down.
That is how it was read down at that stage. But that does not mean, Lord, the legislature for all times to come loses its right to amend such a provision. And the legislature has to stick to that 3-year period, which is, Lord, imported from section 573. And as I showed to your lordship, that 3-year is only in the process of recovery in terms of chapter 16, which clearly says after the bills are presented. So it does not contemplate a situation pre-presentation of the bill. And this was imported at a time because the court found that there was a time limit prescribed in one of the section, therefore that should be read. And that has not been interfered by any of the courts, higher courts, this court in review, it has not, rightly so. But then the point is today that we are on a different situation where the legislature has exercised their authority and power under the statute. So, and exercising whatever the constitutional power they have. The question is, Lord, whether it interferes with the judgment of the division bench. If that is the only test, if it does not, then Lord, question of the wisdom, legislative wisdom, can't be stopped. Now, these are all, Lord, the judgments that I cited. The last one, Lord, page 115.
Yes.
That is 2021. Ghanshyam Mishra,
9 SCC.
Page 85, 162.
Lord, your lordships can ignore this. Please come to page 162. That GP Singh, that declaratory statute, that it is again quoted. So it's not necessary. Lord, it just. May I just indicate the paragraphs 85 and then Lord, paragraph 88 and 89. But one thing at page 166, if your lordships kindly come to, this is part of Lord paragraph 88.
Yes.
Lord, your lordships will find that Maxwell is quoted in paragraph 17, that is Placid, just above Placid. Yes. Now, Lord, may I just.
Yes.
This is, Lord, interpretation of statutes. It says that the rule against retrospective operation is a presumption, etc. If the dominant intention, I just wanted to show this, if the dominant intention of the legislature can be clearly and doubtlessly spelled out, the inhibition contained in the rule against perpetuity becomes of doubtful applicability, as the inhibition of the rule is a matter of degree which would vary secondary material, so and so, sometimes where the sense of the statute demands it, or where there has been an obvious mistake in the drafting, a court will be prepared to substitute another word or phrase for that which actually appears in that text. But this is, Lord, it says that dominant intention of the legislature. Okay.
So this compilation is.
Yes. Lord, just Lord, a few judgments that my learned friends have cited. I just want to deal with them.
So we'll deal with that probably.
I'm so sorry. Didn't look at the watch. I'll deal with the judgments that Mr. Banerjee has cited. Excuse me.
My lord,
I just have three subjects to deal with. One is the judgment cited by Mr. Banerjee.
my lord, kindly keep it after 19th or 20th. My lord, kindly keep it on 19th. I am praying, my lord, on behalf of the state, my lord. My lord, he will not be. My lord, only 19th, my lord. I am praying only 19th, my lord.
Yes, Lord, at 2 p.m. Lord, I tell your Lordship, Lord, so far as the judgments of Mr. Banerjee is concerned, I would not take much time. But Lord, on the 179 2D, that I will take, Lord, a little time on that. And then, Lord, revalidation, I have to cite one or two judgments.
Right.
19th দেবে ওদের সঙ্গে।
18th, 19th, 19th.
18th.
18th.